We're short one board member, but we'll start with the procedural matters. This is the time and place for the Utah Board of Oil, Gas, and Mining hearing on December 9th, 2015. The first agenda item is docket number 2014-044, cause number 139-126 in the matter of Rig 2. And we will now take appearances of counsel.
Clifford Parkinson and Phil Lear of Lear & Lear for the petitioner.
Steve Alder for the Division of Oil, Gas, and Mining.
Okay. Mr. Parkinson, if you would begin. You're going to handle the hearing today?
Yes, I am, Mr. Chairman.
Okay. Proceed.
Hey, Mr. Chairman, members of the board, we're here to hopefully wrap up Rig 2's request for agency action that was initiated in October 21st, 2014, when Rig 2 sought and received an order forced pooling unleased fee lands minerals in the drilling unit for Section 24, Township 2 South, Range 1 East, Uintah Special Meridian in Uintah County, Utah. This matter is governed by the Utah Forced Pooling Statute in Utah Code Section 40-6-6.5. Just a quick procedural history. On March 17th, 2015, the board entered its order forced pooling roughly 9.4% of the private mineral interest that could not be voluntarily pooled, with 90.59% of the private mineral interest that had voluntarily consented to common development. However, the board deferred its order as to the state of Utah and Ute allotted Indian lands that had not been leased as of the January 28, 2015 hearing. Pursuant to Rig 2's motion at that January 28, 2015 hearing, the board took evidence regarding all of the interests of owners of oil and gas in the drilling unit required by law to support a forced pooling order, including its efforts to lease the unleased lands and enter its order forced pooling all unleased or uncommitted private lands in interest in the unit. The board bifurcated its order to exclude lands of the state of Utah and Ute Indian lands, referred to as the excluded lands, allotted Indian lands that are referred to as the excluded lands, and continued the matter as to those lands, allowing Rig 2 the opportunity to obtain leases on the UDOT and the Ute Indian allottee lands. As part of that continuance, the board directed Rig 2 to return and report its leasing progress at a later date. And the board generously continued that date certain on several occasions to allow the governmental agencies having jurisdiction over the excluded lands to pursue and complete their leasing procedures. Rig 2 is here today to provide that report and submit evidence of its leasing and voluntary pooling efforts. In this report and in the evidence submitted, Rig 2 will show that since the hearing in January 28, 2015, the UDOT lands have been leased and the state of Utah has consented to the lease to be voluntarily pooled. Badlands Energy Utah LLC is the current record owner of the pooled lease. Rig 2 recently obtained oil and gas leases covering the Utah allotted Indian lands. Voluntary pooling of the Indian lands can occur only by means of a communitization agreement approved by the Bureau of Indian Affairs and the BLM, and Rig 2 is pursuing such an agreement. While pooling of the Indian leases is a pro forma process, it will take time, and Rig 2 sees no reason why this matter should be continued pending execution of the agreement. Since this is a continued matter, Rig 2 had no obligation to send separate notice to all owners, but it did provide copies of its exhibits to the parties to the hearing. So with this hearing, Rig 2 seeks relief in a number of manners. First, an acknowledgement of the leasing of the excluded lands and the consent of the state of Utah pooling those lands. Second, an amended order acknowledging that all non-consenting interests have been fully and properly pooled pursuant to law. Third, an order dismissing the request for agency action as to the allotted Indian lands so that RIG 2 might pursue communitization of those leases as required by federal law. And fourth, the revising of the acreage weighted land ownership royalty to 16.95% from 16.35%. The matter of some housekeeping matters. Council for RIG 2 has coordinated with the Division Council regarding the method and content of the presentation. Since this is a return and report hearing, Division has consented to RIG 2 offering its evidence in the form of an affidavit supported by limited exhibits. The affidavit is a statement under oath made by RIG 2's land and ownership witness at the hearing, Mr. Tyson Kallstrom. With the leave of the board, we would propose to proffer that affidavit and summarize the salient points, unless the board would like us to read it into the record.
Mr. Alder?
Now, the division has no objection to it being proffered, and we've reviewed the exhibits and have no objection to them, which are part of that.
And in the interest of time, we do have a full agenda today, so that would be accepted.
I did notice that, Mr. Chairman. Thank you very much. Well, so quickly, RIG 2 has provided 7 exhibits for today's hearing, along with revised versions of exhibits 33 and 34. These were all filed on December 1st, and the exhibit list covering exhibits 35 through 41 will give the general outline for our summarization of the exhibits as we proffer them. The affidavit of Ty Kallstrom is an affidavit signed under oath on December 1st, 2015. It describes how the UDOT lands have been leased and how the state of Utah has consented to their being voluntarily pooled. It also narrates the RIG 2's obtainment of oil and gas leases from the Utah allotted Indian lands, Ute allotted Indian lands. And it also notes that as the result of an accounting error, RIG 2 has realized that the acreage weighted landowners royalty from which non-consenting owners royalties are derived should actually be 16.95% rather than 16.37%. So, and that is Exhibit 35. And if with the leave of the chairman and the board, we'd like to move for adoption of all the exhibits after their description and proffer, if that's okay.
That's our preference.
Okay, wonderful. Exhibit 36 is, we are calling the UDOT lease. It was a lease issued on the 12th of June 2015 to Anderson Exploration from DFFSL, affecting the lands identified in the initial hearings as tracts 5 and 11, as they can be seen on Exhibit 5B. If you don't have that Exhibit 5B, which is a tract plat locator in front of you, it's that narrow strip of land at the very top of Section 24. Exhibit 37 is the assignment of that lease to Anderson Exploration, approved of by DFFSL to Badlands Energy Utah LLC. That assignment was approved on July 15th, 2015. Exhibit 39 is a declaration of pooled interest in which DFFSL consents to the pooling of the UDOT lease. Exhibit 40 is an oil and gas exploration and development lease for allotted Indian lands. It covers Lot 5 of Section 24 in the drilling unit in the northwest corner. Contains approximately 27.55 acres, more or less. It appears on Tract 13 of Exhibit 5B. And the lessee is designated as RIG 2 LLC. Indian leases don't have pooling clauses. They are voluntarily pooled under a communization agreement, and RIG 2 is seeking that from the Bureau of Land Management and the Bureau of Indian Affairs. Exhibit 41 is the oil and gas exploration and development lease for allotted Indian lands, and it covers lots 6 and 7, which are located in the southwest-northwest quarter and the northwest-southwest quarter, respectively, of Section 24 in the drilling unit. And these lands appear as Tract 14 on the ownership plat in Exhibit 5B. The lessee, again, is designated as Rig 2 LLC. And again, we mentioned the communization agreement for this lease is being sought from the BLM and the BIA. And this will make a swift departure from your exhibit list to replacement exhibit 33, which is the revised ownership schedule. This replacement exhibit is a revised ownership schedule reflecting updated information regarding ownership to date in the subject lands. We'll note that on Exhibit 3, Badlands is misidentified as Badlands Energy Inc. It should be, we'd ask you to make a pen and ink change that says Badlands Energy M-Utah LLC, if you wouldn't mind doing that. And then we come to replacement Exhibit 34, which is a revised ownership summary sheet. This sheet reflects ownership as it will appear once the necessary assignments of the UDOT leases and the Henry Reeve and George Parvado leases are made under Rig 2's AMI. And we would ask here that it be noted that on the right-hand column to the exhibit.
Which exhibit?
This is Exhibit
34?
34, yes, Mr. Chairman. Oh, you know, I've misspoken. I'm now describing Exhibit 30. In Exhibit, the pen and ink change that I requested for Exhibit 33 is the pen and ink change that we would like in Exhibit 34. I apologize for that.
Okay, yeah, I wanted to make that clear.
And it should be made on the second row down under status. This is Exhibit 34, where it reads Badlands Energy Inc. owning 30.7% of the drilling unit. It should read Badlands Energy M-Utah LLC. And then revised Exhibit 33 is the one where on the right-hand column, it represents that we're showing unit ownership in percentages, when in actuality it's being shown in decimals. We'd ask you to make a pen and ink change noting that, and we apologize for those typographical errors. Having described.
I'm with you.
Sure.
I just want to make sure I haven't missed any. So when you get to the end, let's go through what you're going to offer as evidence today.
And that does, Mr. Chairman, bring me to the end. And so.
So I have, just on my list, I have replacement and revised Exhibit 33 as the first exhibit. Have I missed one?
No, Mr. Chairman.
And then you have revised Exhibit 34. I didn't hear you mention, oh yes, you did mention the affidavit, didn't you? That's 35.
Yes, Mr. Chairman, that's Exhibit 35.
And then I didn't hear 38.
We didn't see that it was necessary to put the agreement of mutual interest in, but if the board would like it there to show how.
It's up to you.
Okay, in which case we'll leave it out.
Okay, so we've got replacement and revised Exhibit 33, revised 34, 35, 36, 37, 39, 40, and 41.
Yes, Mr. Chairman. And so with that, that ends our presentation of evidence in chief. We'd like to reserve a brief time for closing or response to questions.
Mr. Alder.
I think that they should just proceed with their closing. We have reviewed this matter and think this is just a good way to just finalize what took place before and clarify the status of the omitted lands. And we have no objection to the proposed findings of fact and the requested relief.
All right. Any questions of the board? Seeing none, we're back to you,
Okay.
Mr. Parkinson.
Thank you, Mr.
And
Chairman.
if you'd offer your exhibits now.
Yeah, we would offer admission of exhibits revised 33, 34, 35 through 37, so 35, 36, 37, 39, 40, and 41.
No objection.
Board members? Seeing none, they're all admitted.
Thank you, Mr. Chairman. So with the leasing of the UDOT and allotted lands in the interest of all the owners, either being voluntarily or forced pulled with the exception of the 2 Indian leases that will be pulled by communitization, we're going to ask for relief to be outlined in just a moment. Of the non-Indian interests, all interests have either consented to voluntarily participate in the well or they've been forced pooled under the law. The pooling of the Indian leases, as we mentioned, requires consent of the BIA, and Rig 2 is, as we have said, in the process of applying for that pooling. Rig 2 has adjusted its acreage weighed landowners royalty to 16.95% as a result of that minor calculation error. And per statute, no further adjustment of non-consenting owners' royalty will be made, as private lands and leases are only used to determine the average weighted landowners royalty from which non-consenting owners royalties are determined pursuant to Utah Code Section 46.5-6. And as we've already mentioned, Rig 2 and the divisions see no reason why this matter needs to be continued until a communitization agreement with the BLM and BIA is executed and recorded. Consequently, Rig 2 seeks with this hearing an order that first acknowledges the leasing of the UDOT and Indian lands. Second, acknowledges the voluntary pooling of the UDOT lease. Third, acknowledges the adjustment of the acreage weighted average landowners royalty as 16.95%. And fourth, dismisses this matter as to the Indian lands given the issuance of the Indian allotted lands leases and the anticipated ultimate communitization thereof. We thank you for your attention in this matter and your patience in allowing Rig 2 to complete its leasing.
Board members, the matter is now before you. What the petitioner is seeking was just outlined. We can discuss it, or a motion would be in order to approve the request. What is your pleasure?
I move to approve.
I'll second that.
Any discussion of that motion? Seeing none, the motion before you is to approve the request for under this matter. All in favor say aye.
Aye.
Any opposed? Let the record show that was unanimous. Mr. Parkinson, will you prepare the order?
Yes, Mr. Chairman, I will.
Thank you very much.
Thank you. Thank you, members of the board.
And please extend our holiday best wishes to your firm, or whatever's left of it. In these hard times, you never know.
Mr. Chairman, it's very viable. Thank you.
I think he just sees Stephanie in the back.
Okay, we're now to agenda item number 2, the Elite Rock West Mine. This is docket number 2015-023, cause number S/049/0050.
Mr. Chairman, I may just need 3 to 4 minutes to set up a couple items, if that's all right with the board.
We'll just be on hold for 3 to 4 minutes.
Test, test, test.
Yeah. That's right. It's gotta be. Comments on. Looks good. It's a connection somewhere. It's a cable. Yeah, yeah, that's right. Duct tape.
Thank you for your indulgence, Mr.
Okay, we're
Chairman.
back on the record. We'll take appearances of counsel at this time.
Mr. Chairman, John Robinson for the Division of Oil, Gas, and Mining.
Is there anyone else here for this matter? Seeing none, Mr. Robinson?
Thank you, Mr. Chairman, members of the board. Good morning. It's good to be here today, and thank you for your time. As you'll recall, the board ordered a continuance of the Elite Rock West matter in October. In the last 6 weeks since October, some changes have taken place. Namely, the operator has started to reclaim the site. For that reason, you have before you a motion to continue, filed jointly by the division and the operator, Wasatch Mountain Excavating. This morning, I'd like to briefly explain good cause to grant the motion. Since October, as I mentioned, the operator decided to reclaim the site. He mobilized equipment in late November. The division has visited the site and has been on site supervising reclamation activities, and for that reason, the forfeiture action is not right at this time. Thus, both parties feel a continuance is warranted, and assuming good weather, that reclamation will be completed by the January hearing. Finally, as stated in paragraph 8 of the motion, a courtesy copy should be before you. The division stands ready to proceed, provide details through testimony if the board so wishes. Otherwise, I would move to enter that order of continuance at this time.
Board members, in light of our schedule, would you like to have a quick briefing of the reclamation work, or should we save it to the January hearing? Okay. Seeing none, the motion is in order. Then to...
The division then moves the board, Mr. Chairman, to approve the joint motion to continue and move this hearing till the regularly scheduled January date.
Okay. Any questions on that? Are you going to move that? Okay, the motion has been moved. Is there a second? Any discussion? The motion before you is to continue the matter till the January hearing. All in favor say aye.
Aye. Thank you, Mr. Chairman,
Any
members of
opposed?
the board.
And if we need to have an order for the record, will you prepare that, please?
Yes, Mr. Chairman, I'll have one prepared.
Okay, thank you.
Thank you.
As I mentioned earlier, we're going to move the Crescent Point Energy matter to later in the day. And we are now go to agenda item number 4. It is docket number 2015-028, cause number 270-07, in the matter of Ultra Resources. Will you need some time to,
If we could, Mr. Chairman.
please? We're off the record.
Whatever they do, I'm not hard. I saw it there. Yeah.
Purchased by
Oh, that's what that first day was. I don't know who was sitting next to him. He kept doing this, you know. It's okay. It's like, yeah.
Yeah.
First band up there, so,
Yeah, so horrible experience all around.
We're back on the record. We'll now take appearances of counsel.
Seth Lockmiller and Fred McDonald with McDonald and Miller for the petitioner Ultra.
Steve Alder with Utah Attorney General's Office for the Division of Oil, Gas, and Mining.
Being no one else, Mr. Loffmiller, will you proceed?
Let me introduce the witnesses first. We have Craig Blansett, the Director of Land for Ultra, Alec Long, our Senior District Geologist, and David Wall, the Reservoir Engineering Advisor. And can I ask that the witnesses be sworn in, please?
Proceed.
So resumes of all three witnesses were submitted collectively as part of Exhibit A in this cause. Mr. Blansett will in fact be a fact witness only, and Mr. Long and Mr. Wall will be testifying for the first time before the board. Consequently, and pursuant to Mr. Alder's request, we will qualify them as experts in geology and petroleum engineering, respectively, for the purposes of this cause at the commencement of their respective testimony. Can I confirm that the board received a supplement to Exhibit Z, which is the additional mailing receipts which we filed on Monday?
Yes. That has been received.
And can I also confirm that it is acceptable to move for the admission of all of the exhibits at the end of the presentation in chief?
That's our preference.
Well, to summarize the case, today Ultra is before you seeking approval of 2 pilot water flood projects for Middle and Lower Green River oil production within its 3 Rivers field in Uintah County. Board approval of such injection is directly required because the injection is into a hydrocarbon producing zone and for enhanced recovery purposes. As the testimony and evidence presented will establish, Ultra satisfies all the regulatory requirements set forth in Utah Administrative Code Rule R649-5-1 for such approval. The project areas lie within the boundaries of the Uncompahgre Indian Reservation, and underground injection control jurisdiction is retained by the United States Environmental Protection Agency, or the EPA. Consequently, Ultra will be making the appropriate application to the EPA for the actual injection well conversion and approvals.
So just to be clear for the board, it's a water flood application, but you're not asking for our authorization for injection authority. You'll get that from the federal government?
That's correct. Also, Ultra is requesting that the current spacing order, 270-02, be vacated as to the project areas and the suspension of the general well location and sitting rule to the extent inconsistent with the project operations, but maintaining the 460-foot setback from the project boundaries. And a true and correct copy of the 270-02 order was submitted as Exhibit B. Additionally, Ultra seeks board approval and certification of the 3 Rivers project areas as enhanced recovery projects, according to Utah Administrative Code Rule R649-3-37, for purposes of qualifying for severance tax reduction on the incremental production achieved. As you will hear today, these pilot programs are economically feasible, will help Ultra determine the key characteristics of the 3 Rivers area for increased production. Additionally, each water flood project has separate goals and tests separate methods of water flooding, which differ from the pilot water flood the board previously approved in 2014 in the southern portion of the 3 Rivers area, and which help assess full field water, which will help assess full field water flood viability based on the data collected in the proposed pilot projects. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6-53C, 40-6-71, and 59-5-1027, and the Utah Administrative Code Rule R649-3-37 and R649-5-1. A notice was sent via certified mail, return receipt requested, to all of the surface owners, where the owners, as the term is defined by the statute and regulation, and operators within a half-a-mile radius of the proposed water flood project areas, and all mineral leasehold and production interest owners within the areas. The mailings were sent to these parties at their last addresses disclosed by the relevant BLM, TLA, and Uintah County Realty records. The record will also reflect that notice was duly published on November 15th, 2015 in the Salt Lake Tribune and Desert Morning News, and on November 17th, 2015 in the Uintah Basin Standard and the Vernal Express. Letters in support of granting the request were filed with the board secretary by the BLM on November 20th, 2015, and by TLA on December 2nd, 2015. And Mr. Chairman, to the extent that these letters have not been deemed part of the record, we request that they be made so now.
Mr. Elder, any objection to that? Those letters be,
No, they're part of the record. I believe they've been submitted, at least I saw them submitted to the board and to us, and we have no objection to those.
okay, they will be made part of the record.
Thank you. The division elected not to submit a staff memorandum in this cause, and no other objections or responses were received. I'd like to continue now with my examination of Mr. Blansett. Mr. Blansett, can you state your name and business address for the record?
My name is Craig Blansett. My address is 116 Inverness Drive East, Inglewood, Colorado, 80112.
And can you please state your position with Ultra?
My position with Ultra is Director of Land with supervisory capacity over the land records related to the Three Rivers area.
And can you please describe the corporate and bonding status of Ultra?
Ultra is a Wyoming corporation in good standing, with its principal places of business in Houston, Texas, and is relating to the Rocky Mountain operations, including the project areas in Denver, Colorado. Ultra is duly authorized to conduct business in the state of Utah and is fully bonded with all relevant state of Utah and federal agencies. Ultra is a member of UPL Three Rivers Holdings, LLC, the lessee and working interest owner in the leases covering the project areas.
Now, drawing your attention to the hard copies here of Exhibits C through H. Do you recognize these exhibits?
Yes, I do. These,
And who were they prepared by?
they were prepared with my input and review by Ultra personnel.
Now, drawing the board's attention to Exhibit C1 up here on the screen, can you explain this exhibit for us, please?
Yes, Exhibit C is a general locator reference map for the Three Rivers area relation to, you can see its relation to the Natural Buttes and Greater Monument Butte units, and it's just located just north of the town of ooOoo, and you can also see it's near the ooOoo Wildlife Refuge.
And this is specifically for Section 2, correct?
Correct.
And this is Exhibit C2. Can you explain this one for us as well?
This one is specifically, shows the general areas too, with the Natural Buttes to the southeast and the Greater Monument Butte unit to the southwest. And it specifically shows Exhibit Section 3.
This is Exhibit D1. Please explain the significance of it.
Okay, this is Section 2 of the proposed water flood pilot. It is outlined in yellow. The blue dashed line reflects the half-mile radius around the project area. All wells within said half-mile area are shown, including 2 shallow water wells, and they're noted with the blue triangles. Future injector well is reflected with the black dot overlaid with an arrow. It's in the center of that yellow square.
All right, this is Exhibit D2. Can you explain the significance of it?
Yeah, this is a listing of all existing wells in Section 2 water flood area with the production data.
This is Exhibit D3. Can you please explain this for us?
Yeah, on Exhibit D3, we have Section 3 of the proposed water flood pilot, and this Section 3 proposed water flood outline is in yellow. The blue dashed line reflects a half-mile radius around the project area. All wells within the said half-mile radius are shown, including 5 shallow water wells, as noted in the blue triangles. The purple line shows the surface boundary of the ooOoo Wildlife Refuge. You can see that on the east side of the map. The future injection well is reflected with the black dot overlain with an arrow.
And this is Exhibit D4. Can you please explain this for us?
Yeah, D4 represents a listing of all existing wells in that Section 3 water flood area with production data. Please note that there are, the wells with 0 have been drilled but not completed as yet.
And this is Exhibit E1. Can you please describe it for us?
Yeah, here we are with Section 2 again. It's the proposed water flood pilot with existing spacing status under Order 270-02 order. 40-acre unit, the drilling units with 2 well density. Operating rights are entirely owned by UPL.
And this is Exhibit E2. Can you explain this one for us, please?
E2 is represents Section 3 of the proposed water flood pilot with the existing spacing status under 270-02 order. 40-acre drilling units with 2 well density. Operating rights are entirely owned by UPL.
This is Exhibit F1. Please explain this for us, please.
Okay, F1 it represents the surface ownership within the half-mile radius, which is represented by the blue dashed line, and once again the yellow outline represents our proposed water flood pilot area of Section 2, and it includes state trust lands, BLM, U.S. Fish and Wildlife Service, Ute Indian Tribe, and private owners.
And this is Exhibit F2. Please explain this for us.
In F2, we have the surface ownership within a half-mile radius is shown by the dotted blue line of Section 3 of the proposed water flood pilot, and it represents BLM, state trust lands, ooOoo Wildlife Refuge, U.S. Wildlife, Fish and Wildlife Service, and the private ownership.
This is Exhibit G1. Please describe it for us.
G1 shows the mineral ownership of the lands encompassed within the half-mile radius, which is that blue dotted line, dashed line, of the Section 2 proposed water flood pilot. Ownership therein is as follows. The dark blue areas are state trust lands and comprise the whole of Section 2 project area. Yellow areas are federal lands, the gray areas are fee lands, and the light blue are other state lands. The Section 2 project area is entirely covered by state lease ML-49318, commonality of production interest ownership throughout. Therefore, no differing production allocation issues arise with a typical, as you would see with a typical water flood, and UPL is the sole lessee. The surrounding lands are unleased and leased with the leaseholds owned by UPL. The blue dots designate existing wells within the Section 2 project area with the future injector well overlaid with an arrow.
And this is Exhibit G2. Please describe it for us.
Okay, Exhibit G2 shows the mineral ownership of the lands encompassed with the half-mile radius, the blue dashed line, of Section 3 of the proposed water flood pilot. Ownership is designated the same as with the previous exhibit. Section 3 project area is entirely covered by BLM lease UTU-85994, commonality of production interest ownership throughout. Therefore, no production allocation issues arise as with a typical water flood project. UPL is the sole lessee. The surrounding lands are leased and unleased with the leaseholds owned by UPL.
Drawing your attention to Exhibit H here, it's a hard copy. Why don't you describe this exhibit for us, please?
Okay, Exhibit H consists of a list of all production interest owners and operators and all surface owners within a half-mile radius, which is that blue dashed line of the project areas. This exhibit is compiled from Ultra's internal land records, including title opinions and a search of BIA, BLM, and Division of Forestry, Fire, and State Lands records, and the trust lands and Division of Oil and Gas and Mining and Utah State Engineer and Uintah County records prior to filing the request.
All right. Now, drawing your attention to, have here the certificate and supplemental certificate of services, which are already on file in this matter and were prepared by myself. Do you recognize these parties?
Yes, I do.
And who are these parties and addresses?
These are the same parties as shown on Exhibit H, those required to be notified under Utah Administrative Code Rule R649-5-1, and they're compiled from the same sources as previously testified.
Now I'm going to draw your attention to Exhibit Z as supplemented. It is they're true and correct copies of the certified mailing and return receipts that were received by McDonald and Miller, and confirm the receipt of a copy of the request for agency action by all such parties, and supplemented on Monday to reflect the receipts and mailings received after November 9th, 2015, which was the exhibit filing deadline. And that concludes my examination of Mr. Blansett.
Mr. Alder,
Mr. Chairman, thank you. We have no questions for Mr. Blansett.
board members? I have one, just one matter, just to clear the record out. It's a two-part question. The first one, UPL, will you define what that is, and then will you just describe its relationship with the applicant in this case, which is Ultra Resources?
Yeah, UPL is a lessee of Ultra Resources, so they're it's their entity that's doing business in the state of Utah.
Thank you. Okay. Thank you, and back to you, Mr. Loftmiller.
All right, now commence my examination of Mr. Long.
Welcome, Mr. Long. We normally give new geologists a really hard time.
I'm looking forward to it.
Can you state your name and business address for the record?
My name is Alec Long, 116 Inverness Drive East, Englewood, Colorado, Suite 400, 80112.
And can you state your current position with Ultra, please?
Senior District Geologist responsible for the evaluation and development of the Three Rivers Field.
And can you outline your education for us?
I earned my master's in geology from the University of Arkansas in 2005.
And can you give us a brief description of your work experience, and particularly including your experience in the Uintah Basin?
From 2005 to 2010, I worked the Granite Wash play in the Anadarko Basin and the North Louisiana Salt Basin Haynesville Shale play. From 2010 until 13, I worked Cretaceous oil sands in the Powder River Basin, and for the last 2 years, I've been with Ultra working the Uintah and, in particular, the Three Rivers Field.
And can you describe any certifications or publications you have?
Just the masters.
All right. Mr. Chairman, I move to have Mr. Long recognized as an expert in geology for the purposes of this cause.
No objection, Mr. Chairman.
Board members? He shall be so admitted.
All right, thank you. Drawing your attention to the hard copies here, Mr. Long, of Exhibits I through K. Do you recognize these exhibits?
Yes, I do.
And who are they prepared by?
Myself.
Drawing your attention to Exhibit I-1 up here on the screen. Can you please describe this exhibit for us?
I-1 is a subsea TVD structure map of the Section 2 project area projected on top of the Lower Green River. This also shows the regional dip to the north with no major faulting, conducive to water flooding. This also provides a cross-sectional reference for Exhibit K1 and location of the type log well used for the stratigraphic definition in Exhibit J1.
And this is Exhibit I-2. Can you describe this for us, please?
I-2 is a structure map on the Lower Green River like we saw in Section 2. This is for the Section 3 project area, and it also provides the cross-sectional reference for Exhibit K3. If you'd please note that the location of the type log is actually incorrect. It should be on the 313 well, the well just to the south.
And we will file a corrective exhibit post-hearing that shows that.
Good.
Now, this is Exhibit J1. It is given as required under Utah Administrative Code Rule R649-5-2.6. Can you please describe this for us, Mr. Long?
This is a type log for Section 2 of the water flood pilot for the Lower Green River. It's taken from the Three Rivers 213-820 well. It shows the markers of the various formations as well as the spaced under 270-02 and proposed injection zone, which is required under Utah Admin Code R649-5-2.6.
All right, and this is Exhibit J2. Can you describe this for us?
This is a type log for Section 3 of the water flood pilot for the Lower Green River, and this is taken from the 313-820 well. It also shows the markers of the various formations as well as the spaced under 270-02 and proposed injection zone required under Utah Administrative Code Rule R649-5-2.6.
And this is Exhibit K1. Will you please explain this exhibit for us?
K1 is a geologic cross-section through Section 2. This cross-section for the various wells in Section 2 travels in a line from point A to A prime. The map showing this line in relation to Section 2 appears on Exhibit I-1. Here we show the proposed Lower Green River water flood interval by the red bar in the middle. Notice that through the water flood interval, the layers consist of regionally continuous limestones and limey sandstones in the lower layers, but become more sandy and locally continuous at the expense of the limestones as we move further to the east. The upper layers also consist of mostly locally continuous sands. These layers are conducive to a water flood project.
And this is Exhibit K2. Can you explain this for us, please?
K2 shows upper and lower confining intervals in Section 2 water flood pilot. It shows the upper and lower intervals consist of about 40 feet of regionally continuous shales and siltstones acting as confining layers, which will prevent uphole migration. The proposed water flood interval of the Lower Green River pay zone is between these two confining layers.
This is Exhibit K3. Please explain the significance of it.
So this is a geologic cross-section through Section 3. This cross-section for various wells in Section 3 travels in a line from point B to B prime. The map showing this line in relation to Section 3 appears on Exhibit I-2. Again, we show the proposed Lower Green River water flood interval by the red bar in the middle. Notice that through the water flood interval, the layers consist also of regionally continuous limestones and limey sandstones in the lower layers, but become more sandy and locally continuous at the expense of the limestones as we move further to the east. The upper layers are also consist of mostly locally continuous sands. These layers are also conducive to a water flood project.
And this is Exhibit K4. Please explain the significance of it.
K4 also shows the upper and lower confining intervals in Section 3. These intervals consist also of about 40 feet of regionally continuous shales acting as confining layers, which will prevent migration. The proposed waterflood interval of the Lower Green River pay zone is between these two confining layers.
Now, Exhibits I through K are also submitted to comply with Utah Administrative Code Rule R 649-5-2.4 through 2.6. Now, Mr. Long, can you differentiate the geology in Section 2 and Section 3 here from the geology in the Section 16 pilot, which was done in 2014?
The lowermost intervals in Section 16 consist almost exclusively of carbonates, regionally continuous carbonates. As we move to the east, Section 3 in the lower section has a mix of carbonates and sandstones. And by the time we're reaching into Section 2, the lower section is almost dominated entirely by sandstones.
Now, Mr. Long, is it your expert opinion that the geologic characteristics of the project areas make them attractive for a water flood project?
Yes.
And is it also your expert opinion that the upper and lower unfaulted and confining layers of the shales and siltstones are sufficient geologic barriers to prevent migration?
Yes.
That concludes my examination of Mr. Long.
Mr. Alder.
Mr. Chairman, if you would allow Mr. Dustin Doucette has a question for the witness.
Proceed.
Yeah, as far as, if you could turn to maybe Exhibit J1. And I guess between J1 and J2, is your plan to flood all these open perfs in the interval, or you had mentioned there's some differences between Section 2 and Section 3. Are you going to just isolate specific zones, or is that part of the plan, is to kind of find out the best way to flood these zones?
The Section 2 injection well has already been completed. The Section 3 injection well will be completed as a dedicated injector.
But will you at the same time flood all that entire zone or interval that you've got designated here?
Initially, yes.
Okay. And then maybe as you find one zone's taking more fluid, you may adjust that?
Yes, sir.
Okay. Thank you.
Board members, any questions?
Mr. Chairman, I did have one additional question.
Please.
First, if you don't mind. So, Mr. Long, I didn't understand the answer to the last question that your counsel asked you about differentiating between the two proposed water floods and the previous water flood to the south. Could you repeat, or what is the significance of the differences between the geology of those proposed projects, and what was the reason for that question?
Right. The lowermost intervals in Section 16 on Exhibit J1, the top of the Castle Peak and below, Section 16 is almost dominated entirely by carbonates. As we move into Section 3, that interval is a mix of carbonates and sandstones. And as we get to Section 2 further to the east, it is dominated almost entirely by sandstones.
So you've referred to two Section 2s. The first Section 2 is the previous water flood project that was approved.
Section 16 is the previous approved.
So you said what those differences are. What difference did they make in the proposed water flood project?
We would like to test the injectivity of various facies in the Section 3 and the Section 2.
So it's the fact that they're different that makes them important. That's
Yes.
important.
So we can assess the viability of those intervals in the full field water flood development.
And what is the depth from the surface waters to the levels that you will be injecting into?
The deepest water wells are 100 feet or so, I believe. And then the top of the injection interval is roughly 5,000 feet of measured depth.
Thank you. No other questions.
Thank you very much. Board members?
What do you plan to use as a water supply for your injection here?
That's probably best answered by David, our engineer.
Any other questions? Go ahead.
Could you just explain a dedicated injector design versus a regular well converted to a injection well?
We will probably perf a more discrete interval in the injection well with the lessons that we've learned in section 16, as opposed to our primary production in section 2, which was to complete the entire interval.
So it won't be produced at all?
That's probably better answered by David in the engineering.
Just a comment, we appreciate how self-explanatory your exhibits are. Thank you.
Thank you, sir.
Okay, call your next witness.
Going to commence our examination of Mr. David Wall at this time. Mr. Wall, can you state your name and business address for the record, please?
My name is David Wall, and
Mr. Wall, because this is recorded, you almost need to have your lips on the microphone to really make this system work. Would you try that again?
Yes, sir. My name is David Wall, and address is 116 Inverness Drive East, Suite 400, Englewood, Colorado, 80112.
And can you state your current position with Ultra, please?
I am a reservoir engineering advisor.
Now, you also have responsibility over the Three Rivers field, is that correct?
Yes, that's correct.
And can you outline your education, please?
Yes, I got 2 bachelor's degrees from Colorado School of Mines last century in 1990. And I got 1 in petroleum engineering and 1 in mechanical engineering.
And can you describe your work experience and with particularly your experience in the Uintah Basin and with water floods?
Yes, so I've worked for Ultra Resources for the last 1.5 years in the Three Rivers area. Prior to that, I worked for Newfield in the Greater Monument Butte water flood, developing reservoir engineering and project descriptions. And prior to that, I worked for Era Energy, which is a wholly owned subsidiary of Shell and Exxon in California for 14 years. Most of that was in the Bell Ridge field, which is one of the larger water floods in the United States. I worked several different positions, completions, operations, and reservoir engineering in the water flood. And in the last few years, I worked on a tertiary steam flood project within that field, which is subsequent to water flooding.
And do you have any certifications or publications that the board should know about?
Not at this time.
Mr. Chairman, I move to have Mr. Wall recognized as an expert in petroleum engineering for the purposes of this cause.
Mr. Alder.
Thank you, Mr. Chairman. We appreciate the background information. Have no objection.
Board members? Mr. Wall will be admitted for the purposes of petroleum engineering.
Thank you. Mr. Wall, just to start us off here, will you provide us an overview of the project in Section 2?
Yes, so in the Section 2 water flood pilot, we'd primarily would like to evaluate an 80-acre inverted 5-spot pattern configuration. We'd like to determine the injectivity into the different layers as shown in Exhibit K1 of the Lower Green River. We'd like to measure the production response and timing of those production wells in the pilot and identify with tracer surveys how much each injection zone will take. And the estimated maximum injection rates is 1,500 barrels of water a day, depending on the injectivity with the rates approved by the EPA. In Section 3, we'd like to test the injectivity within an injection well that is completed specifically for water injection, as opposed to the Section 16 pilot and the Section 2 pilot, where these wells would be converted to injection after production. The Section 3 pilot injector would be completed specifically as a water injector with different completion procedures. We'd also like to evaluate a different pattern configuration, a direct line drive pattern configuration in Section 3. And the maximum injection rates would be the same as in Section 2, 1,500 barrels a day and approved by the EPA.
And can you differentiate these two project areas from the Section 16 pilot?
Yes, so the different geology, as explained by Alec, is one fundamental difference between the Section 16 pilot and the Section 2 and 3 pilots. We also have different pattern configurations in all 3 pilots. Section 2 would be an inverted 5-spot, and Section 3 is a line drive configuration. And also in Section 3, we would have a new injector completed for the specific purpose as a water injector. And to speak to the water sourcing question, which was asked at Mr. Long, we have sufficient produced water for our water injection pilots currently, and if at some point we would need additional water, we have agreements in place to provide that water.
And do you expect this project to impact any of the adjacent lands?
No, we do not.
Well, Mr. Wall, I'm going to draw your attention here to Exhibit L and M, the hard copies. Do you recognize these exhibits?
Yes, I do.
And who are they prepared by?
They were prepared by myself and Ultra personnel.
This is Exhibit L1 up on the screen. Can you please describe this exhibit for us?
So Exhibit L1 shows the water flood plan and the facilities associated with that water flood. In Section 2, the gold outline is the water flood area, and the red and blue lines are existing gas and water lines. The green triangle is the proposed injection facility, and that will be placed on an existing pad.
And this is the Section 2 is testing the diamond pattern, is that correct?
That is correct, yes.
And this exhibit was given as required by Utah Administrative Code Rule R649-5-2.2. This is Exhibit L2. Can you please explain this for us?
Yes, so similar to L1, the gold outline is the proposed water flood project area. The red and blue lines are the existing water and gas lines, and the green triangle is where a facility would be placed for the injector on an existing pad.
And this would test the line pattern, is that correct?
Yes, that is correct.
This was also given as required, or this exhibit was also given as required under Utah Administrative Code Rule R649-5-2.2. Now this is Exhibit M1. Can you explain the significance of this exhibit, Mr. Wall?
So for the Section 2 pilot, the fundamental economics are the infrastructure cost at $433,000 estimated, and we estimate the potential incremental oil recovery is 321,000 barrels of oil from the Section 2 pilot, which is economic at prices lower than $50 a barrel.
And this is Exhibit M2. Can you summarize this one for us, please?
Yes, so the critical components to M2 show the Section 2 production rates on the chart on the right, with the black bars showing what production would be without a water flood, and then the green bar showing what production would be with a water flood. We estimate an incremental 321,000 barrels of production at an incremental cost of $1.35 per barrel. And on the bottom of M2, you see a map showing the water flood area and then the proposed diamond inverted 5-spot pattern in the red dashed lines inside that water flood pattern.
Now this is Exhibit M3. Can you describe this exhibit for us?
Yes, so this summarizes the economics for the Section 3 water flood pilot. Estimated capital is a little over $1 million, and the potential recovery is 251,000 barrels from secondary recovery. It would be also economic at less than $50 a barrel.
And this is Exhibit M4. Please summarize this exhibit for us.
So this exhibit shows, with the chart on the upper right, the production, what it would be without a water flood is shown in the black bars, and the incremental production from water flood is shown in the green bars. With 251,000 incremental barrels produced, that's a capital cost of $4.13 incremental per barrel.
Now, Mr. Wall, is it your expert opinion that water flood is needed to recover resources that would otherwise be left in place?
Yes.
And is it also your expert opinion that the value of projected incremental production substantially exceeds the cost incident to enhanced recovery operations?
Yes.
That concludes my examination of Mr. Wall.
Mr. Alder.
Thank you, Mr. Chairman. Mr. Doucette has a question or two for the witness, if you would allow.
Yeah, if you want to turn maybe to Exhibit L1. So I know you're doing an inverted 5-spot here. You've got a couple 40-acre spots still open. Are there any plans to drill those wells?
There's no plans to drill those wells at this time.
Okay, and then on L2, kind of a similar question. You've got a few wells that have been drilled but not completed. Is the plan to complete those wells prior to injection, or?
There's no current plans to complete any of the other wells that have been drilled and not completed, other than the injector well at this time. So those volumes from the additional wells were not included in the economics. I think on Exhibit M4.
So that does not account for any recovery from those drilled wells?
That is correct.
And it doesn't anticipate, it doesn't use the cost for drilling those wells either then? Is that correct?
That is correct.
Okay, no further questions.
Just one other question, if I could, Mr. Wall. Where is the produced water? Is it held on site, or will it be pumped to the injection well locations? Or how will that water be handled?
So the existing water lines that go to each pad, we just need to place essentially a pump and filter equipment to get the right water quality and pressure on the pad. And we don't need to supply any more infrastructure, since the water gathering or distribution system is already in place.
So where is the produced water held now? Just downhole still?
So for the whole field, that water, some of it goes to the Section 16 water flood, and then some water also goes to a disposal well.
Okay. No other question. One more question, if we could, Mr. Chairman.
So just a point of clarification, will each water injection site have a treatment facility to prepare the water?
Yes, we'll have one on section 2 and one on section 3, which are shown on exhibits L1 and L2. They're the green triangles that are shown on each of the pads.
Okay, so the water will be piped or trucked from the produced area to this facility and then injected.
So the water will be supplied through the dashed blue lines that you see on the map, and that will supply water to that pump and filter at that location.
Thank you, Mr. Chairman. That's all the questions we have.
Board members, pardon me, board members, any questions?
What is the time frame for doing this?
I think one of the longer lead items may be EPA injection approval. And we estimate when we have all the necessary approvals that we'll commence the project as soon as we can.
Thank you. That back to you, Mr. Loftmiller.
I move for admission of Exhibits A through M inclusive with the correction of Exhibit I2 and Exhibit Z as supplemented.
Mr. Alder,
No objection to the admission of the exhibits.
board members. So exhibits A through Z as supplemented with a notation that I2 will be corrected. They're admitted.
Thank you. And can I reserve just a few minutes to respond to anything
Yes.
at the end? Thank you.
Mr. Alder.
Mr. Chairman, John Rogers, the Associate Director for the Oil and Gas Program, would summarize the division's position with regard to this proposal and request.
Thank you. Mr. Rogers.
Due to the success of the pilot program and the similar geology in this area and the economics presented, the division supports this action.
Anything else, Mr. Alder?
No, thank you.
Board members, any comments? We're back to you, Mr. Loftmiller, and I would just make a personal comment. This is one of the better water flood presentations in terms of explaining what is going on in terms of the exhibits. We compliment you on that. Well done.
Thank you.
Could summarize what you would like here so the board is clear on what you're asking for?
Sure. So the statutory and regulatory requirements for granting Ultra's request have been satisfied and will allow for greater recovery of resources without waste and with full protection of correlative rights. And these pilot projects will provide necessary data for possible future projects in the Three Rivers area. Thank you for your time, attention, and consideration of this matter.
Okay, board members, we can take this under advisement, or a motion would be in order.
I move that we approve their petition to water flood these two areas.
I'll second that.
Any comments or discussion? The motion before you is to approve the request for agency action as written. All in favor, say aye.
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 Any opposed? Let the record show that that was unanimous. Mr. Loftmiller, will you prepare the order?
Yes, Mr. Chairman.
Thank you very much. Board members, audience, we're going to take about a 10 to 15 minute break to let the next party. I think what we're going to do here, so we're off the record. What we're going to do here is we're going to move to Crescent Point, provided that their witnesses and the attorney are present. Are they here at this time? We're doing that with the understanding that the BMC, Seabridge Road attorney and witnesses were advised that they wouldn't be needed until after lunch. Is that correct?
Yes, thank you, Mr. Chairman.
So we're going to go to Crescent Point, and then what we will do is we're going to try and find a break point right about noon to take a lunch break as close as we can. So Crescent Point, if you would be prepared to proceed in short order. Thank you. We now are having a break. Hey, are the parties ready? Are you ready to go? Mr. Alder? Okay, we are back on the record. This is agenda item number 3, docket number 2015-026, cause number 131-141, in the matter of Crescent Point Energy, U.S.
Good afternoon, everyone. I'm Brent Chicken with Fox Rothschild Counsel on behalf of Crescent Point Energy U.S. Corp. I believe, given the issues that we'll be addressing today, I'm just going to make a brief introduction, and then we can go into our
Hey, let me just get one thing on the record. I want to take appearances. So you're here. Do you have Mr. Llewellyn with you?
No, Mr. Llewellyn is not attending today.
Okay. And other counsel?
Steve Alder with Utah Attorney General's Office, representing the Division of Oil, Gas, and Mining. Thank you, Mr. Chairman.
Anyone else here in this matter? Thank you. Mr. Chicken, please.
So as I was saying before, I'd like to just give a brief introduction to kind of frame what we'll be talking about so everybody's on the same page. As everyone knows, Crescent Point's been an active operator in the Uintah Basin for many years now, and in that time has learned a lot about the geology. Has learned a lot about the geology of the Randlet area of the basin, and specifically the engineering necessary to efficiently and effectively produce as many hydrocarbons as they can from it. And through these efforts that CP has made, it's clear that the future of this basin is going to be firmly grounded in development plans that combine all the low-cost benefits of vertical wells and the high production yield results of horizontal wells at the same time. To date, Crescent Point has implemented this vision primarily through drilling wells pursuant to the rules of the division and a previously issued pilot order that this board's issued. But the information and data that they've gained from that really has indicated an absence of a magic formula for the area that we're going to be talking about today there in Randelette. Instead, really, what it's led Crescent Point to believe is that despite the common characteristic pools, or the common pool characteristics, of the Lower Green River and Wasatch formations, you can have widely varying production results depending on both not only the specific zones within that common pool that you target, such as the Castle Peak, Uteland Butte, Douglas Creek, etc., but also the extent and thickness of the same when you start looking at larger pieces of acreage and how that formation acts. When these operational issues are combined with the regulatory and permitting challenges that operators face, and specifically in Crescent Point's case, because we have a large amount of tribal land and a lot of Endangered Species Act and Clean Water Act and other similar issues, Crescent Point's realized that to efficiently, effectively, and economically develop the Randelette area in a manner that's going to protect correlative rights and prevent waste is really only going to be accomplished through a comprehensive regulatory framework rather than piecemeal treatment that will allow Crescent Point to permit, drill, and operate wells and distribute production in a flexible manner. And so what we're seeking today is a regulatory procedure that permits Crescent Point to designate drilling units in that Randelette area on a geology and engineering driven case-by-case basis that can often dictate different operational results even for adjoining lands right next to each other. And in order for that development plan to move beyond the kind of one-off drilling that they've been doing thus far, I'm sorry, I keep moving away from the microphone. That regulatory framework also has to provide enough predictability so that Crescent Point can allocate capital expenditures over a 5-year period, hopefully starting in 2016. And this is also the best way to ensure that pipelines and access roads and the other facilities are going to get permitted and located in a manner that minimizes impacts to the land, but also can take advantage of those economies of scale. And all of this is to benefit of the operator, the non-operators, mineral owners, et cetera. So based on these concepts, our request today is really simple at its heart, and we're going to try and explain that as best we can. Crescent Point wants to be able to designate vertical, short lateral horizontals, and long lateral horizontal drilling units and allocate the production from those units in a flexible manner that both is calculated to protect correlative rights, maximize recovery, and prevent waste, and is undertaken with transparency, pursuant to procedure that's fully understood and approved by this board, and that allows us to keep coming back to the board and providing more information so that the board's oversight functions are fulfilled. Crescent Point, thus far, we've worked with and will continue to work with division staff, division attorneys, and providing updates as necessary for Crescent Point's progress and results. We've also been in communication with mineral owners and working interest partners who we've entered into agreements with in certain cases, but with respect to mineral owners, it's actually been interesting. Not only do we not have any protests of our application, but we've had several mineral owners that call us, and once we've talked to them a little bit, they're not only not protesting, but they're in favor and willing to support and facilitate what Crescent Point is asking for today. So to explain all these issues with me today are Crescent Point's Western District Landman Ryan Waller, to my left, Senior Geologist Laura Roberts, and Senior Engineer Katie Matthews, both of whom are behind me. They're all intimately acquainted with the Randlet area, and they've testified before this board in their respective areas. And with that, I'd like to call...
Let's get your witnesses sworn at this time, if we could. You have them...
Collectively or piecemeal? It's up to...
Collectively.
Collectively, okay.
Yes.
Okay. And call your first witness and have him spell his full name, if you wouldn't, or at least your last name for the record.
Sure. My first witness will be Ryan Waller. Mr. Waller, if you could please spell your last name for the record.
Sure. W-A-L-L-E-R.
And Mr. Waller, how are you? Who are you employed by?
Crescent Point Energy, U.S. Corp. The address is 555 17th Street, Suite 1800. That's located in Denver, Colorado, 80202.
And what's your role with Crescent Point?
I am the district landman over our western region. Basically, that entails title review, leasehold acquisition. I work on acquisition and divestiture projects, and I also oversee operational notices regarding drilling wells, recompleting wells, working over, et cetera.
Okay. And can you just give the board a brief synopsis of your education and background as well?
Sure. I graduated with a bachelor's degree in petroleum land management from the University of Oklahoma. Since then, I have worked for several operators in the basin, the Uintah Basin. First, I went out of school working with El Paso Energy, and then that's now EP Energy. From there, I went to Newfield Exploration. I worked there for several years prior to coming to Crescent Point. I've now been at Crescent Point for nearly 3 years in the current position that I'm in.
Thank you. I'd like to offer Mr. Waller's testimony today as fact witness testimony. Moving forward, we'll go to Crescent Point's first exhibit. This is Exhibit A. Mr. Waller, can you please describe this exhibit?
Sure. This is our regional locator map, and it also shows the relevant causes that I'd like to briefly touch on. But first, a brief summary of the well densities that we're requesting today. We want a maximum of 16 vertical wells per section. Essentially, this is going to be exactly the same development for vertical wells as we have been doing out here for the past several years. We've been doing that under the general siting rules of Utah, R649-3-2. These vertical wells will be on 40-acre units as they're drilled. Then we're also asking for a maximum of 12 horizontal wells per unit. I think a point of clarity here is that we will get into more detail through our testimony on this.
Just as for clarity purposes, there's I don't know what label you want to put on them, but when you talk about horizontal wells, let's have a label that's 2-mile wells or 1-mile wells. Other petitioners have called them super long laterals for the 2 miles, and just the long laterals for the 1 mile. But
sure.
You choose how you want to handle that.
I'll try to remain consistent, and we'll go with long laterals and super long laterals. Long laterals being 1 mile, super long laterals being 2 miles.
So when you say 12 wells, what the horizontal wells?
Sorry, go ahead.
That's super long or just long lateral?
That max would apply to both. So we're going to have instances where you could have a unit that is 1,280 acres. This unit would be established by drilling a super long lateral, but that unit could also have just long laterals in it. So it'd be a combination of long laterals and super long laterals within that same unit. That max applies to both well types. So again, those designated units can be 640 acres, that's one section of land, or 1,280 acres, that's 2 sections of land. Our 1,280 acre units would be vertically oriented. I did just briefly touch on it, but the effective dates of those units would be from the first production of the first horizontal drilled. So if we drilled a long lateral horizontal and it came on production, that would establish a 640 acre unit. If we then came back and drilled a super long lateral and that came on production, that would then establish a 1,280 acre unit. And it would be from that point going forward, it would not be retroactive on prior drilled wells.
When you say vertically oriented, do you mean north-south?
North-south, yes, sir.
And
we generally refer to those as stand up.
Stand up.
And board will be going into that in much more detail.
Board members, just so you know, I talked to Mr. Chicken yesterday, and he offered that if we have any background information or terms that they use that we're not familiar with, to ask questions at any time.
Please.
Absolutely.
If that interrupts your flow, we'll stop it, but is that offer still on the table?
Absolutely, and there's, as far as we're concerned, there's no flow to interrupt. We want complete transparency and everybody to be on the same page at every stage. So, you got a question? Just jump right in.
If you have a question, let me know.
Great. So again, they're effective from the production forward. They're not going to be retroactive on prior drilled wells. And then the setbacks that we're requesting for these long lateral horizontals and super long lateral horizontals are going to be 330 feet from the north and south line and 560 feet from the east and west line. So those are reduced from the general well siting rules for horizontals in Utah. So getting into the regional locator portion of this exhibit, we are in our Randlet area. This is in northeastern Utah. It's generally between the towns of Vernal and Roosevelt. So we're southwest of Vernal and southeast of Roosevelt. We're directly south of the town of Fort Duchesne, and then it's named Randlet because the town of Randlet is pretty much right in the middle of this acreage. So moving to the legend here to identify these outlines, the green outline is our proposed cause 131-141 that we're discussing today. This is 45 sections of land. The blue outline is our horizontal pilot order that Brent referenced in his introduction. That was for horizontal development only. The red outline I thought was relevant to this because it's right next door and it was a fairly similar spacing order that was approved for Newfield a few months ago. I say it's similar because it addresses kind of similar well development strategies. It addressed long laterals, super long laterals, as well as vertical well development all in the same units. And then that was 90 sections of land, so comparatively it was a larger order as far as the land base was concerned. The orange-ish yellow outline is cause number 142-05. This is a vertical spacing order. It's been in place for some time here. It does lay down 80-acre units, 2 wells per 80 acre, and it's vertical only. As you can see, only a small portion of that order goes into our outline for 131-141. It's 160 acres. There are no vertical wells producing in there. We're simply addressing that to vacate that order as to that small portion. Lastly, I want to identify Section 34 of Township 3 South, Range 2 East. This is the green kind of cross-hashed box. We are excluding that section from this request. That was through working with some of our partners. We decided that it would be best to leave it out for now, and it may be addressed in the future for a similar type of an order, pending further analysis and negotiations. Another thing I'd like to note here is if you're referring back to the request for agency action and comparing that to my exhibit here, the lands don't necessarily match up as far as the sections that we listed in the request. That is due to us having removed several sections. I already named one, Section 34 of 3 South 2 East, and then we also removed Sections 13, 18, and 19 of Township 4 South 2 East. Similar situations, just discussions with partners and offsetting owners likely to be revisited in the future. Just thought it was best to remove them for now.
So, Mr. Waller, just a follow-up question, and this, just to provide a little guidance to the board. Despite the visual depiction of the lands, is it do you believe that we've tried to decrease some of the complexities by removing some of those lands?
I would agree, yes. It is an interesting looking outline, but as we'll get into later, it is designed to help us address our field. It's mostly owned by Crescent Point, and it has a minimal impact on existing production as well as other working interest owners.
This is Exhibit B. Mr. Waller, could you please describe Exhibit B, please?
Sure. This is our notice outline and our 1 mile buffer. Again, it's our cause 131-134 outline. Within that outline, we notified all of the production interest owners, so that would be leasehold, mineral, unleased mineral owners, royalty owners, overriding royalty owners, basically anyone that would have an interest in a well drilled within these lands, we provided notice to. And then also we have in the blue hashed outline there is a 1 mile buffer. In that area, we notified all the working interest and unleased owners. The reason for doing so was the reduced setbacks that we're requesting that I mentioned earlier on Exhibit A. So to come up with these lists, we have title opinions that was prepared by our title attorney over much of these lands. And then where we don't have that, we did extensive title research in the Uintah County Courthouse to come up with these lists of interested parties.
Do you have any further comments regarding Exhibit B?
If there's no questions, I'm good with that.
The board saw, I skipped over Exhibit C. It was simply the RAA, which is of record already. This is Exhibit D. Mr. Waller, can you please describe the information on Exhibit D and explain?
Absolutely. This is our land summary. This was at the request of the division to try to kind of get a better understanding of our interest in the mineral ownership within these lands. I think the key highlight from this slide is, as I mentioned before, we have a very high working interest in these lands. Throughout the subject lands, we have an average of 97% working interest. The bulk of the remaining 3% working interest is leasehold or unleased mineral owners that typically participate in the wells that we drill. So we have good relationships with them, and they're very respective of what we're doing out here and appreciate the development that we've done. There is a very small portion, roughly 220 acres, that is unleased, that we either cannot locate or we have not bad title, but complicated title that we're working through to try to get that leased. So moving to the mineral ownership breakdown, the majority of this, 66%, is tribal or Indian allotted. We have leasehold agreements and contractual agreements with the tribe and the Alati Indians that have very long terms to them. Much of this is almost a decade of development that we can do. So that's 66% of this area. 31% of it is fee land or private minerals. 2% state and county, and then less than 1% is federal. So moving on to the lower part of this exhibit, this is where you might want to feel free to jump in with questions. Again, at the request of the division, we were trying to lay out a process for force pooling under this order, as it is fairly complex with the units and the wells. So this is my attempt to lay out a process, and again, this could be altered or incorporated into a final order. We can work that in, but just chime in if you have any questions on it as I go through it. One thing to note is there are 0 force pooling orders on these lands currently. Largely due to the fact that we have not developed them heavily yet. But if we were to force pool going forward under this order, I kind of see it going as follows. So we're going to have 3 unit sizes, 40 acres for vertical wells, 640 acres for long lateral horizontals, or super long horizontals, long horizontals, and then 1,280 acres for super long horizontals. So what we would do is if we were to go and propose a well of any of those types, we would AFE our unleased mineral owners or our fellow working interest owners based on their proportionate share in those units. Again, it would be dependent on the type of well that we're drilling. If we cannot locate someone or they refuse to participate in the operation for some reason, we would obviously attempt to execute an operating agreement with them and handle it that way. But if we must, we would likely initiate a force pooling hearing with this board. What that force pooling order would do is basically conform to the unit size in place. So if we had drilled a vertical well, it'd be 40 acres. If we had drilled a long horizontal, it would be 640, and a super long horizontal, it would be 1,280. And what we'd have to have that do is apply to every well within that unit. And that's where it gets a little bit complicated. But what we would want to do for fairness and consistency amongst all of our owners, if you had a well that was on production that we drilled prior to making a unit effective, say a vertical well, it's on a 40, and then we come back and we drill a long horizontal and then establish a 640. That vertical well was on production prior to that unit becoming effective. Suddenly you have owners that were not previously in that vertical well would then have an ownership share in it. We would not want to assess a penalty against those owners for that well. We would simply want to recoup our cost and move forward with it from there. We would, though, want to potentially assess a penalty on the horizontal well that established that unit, as well as any other wells within that unit going forward from there. Is everybody with me on that? I have a visual slide. If we could maybe jump forward, that might help me explain that a little bit more.
Go back. Yeah, you lost me a little bit.
Okay.
Let's try. It has to do with the force pooling. We call it risk allocation factor. The industry calls it the force or the non-consent penalty. But
right. Oh, sorry. Right.
And
so on a typical.
Maybe I can clarify this a little bit, and I think the exhibit may contain a term in here that's a little confusing, and that is exactly what the board's talking about, is the distinction between the recovery of cost and the imposition of a penalty. The concept would be that if there is vertical wells on production prior to one of the horizontal wells being drilled, and there was to be a pooling, a statutory pooling of those wells, the vertical wells, there would be cost recovery pooling only and no penalty. So we would only recover cost on those vertical wells.
The difficulty with that is that our statute requires something.
I understand it
And
requires.
so I don't know how you're proposing to get around that.
The
We're not
statute
going to bog down on that point right now.
Statute does
but
require the imposition of a penalty. What Crescent Point is willing to do is not collect the penalty, regardless. In other words, no penalties for any vertical wells on production beforehand. And I'll ask Mr. Waller another question. Would Crescent Point intend to whether they are pooling a 40, a 640, or 1280, do you anticipate coming back to this board in each one of those cases to repool if necessary? In other words, every time there was a pooling, you would be seeking a board order for that. There would be no bootstrapping of prior orders. Is that correct?
That's correct, yes. We'd go through the notification process, we'd come to the board, and we would address it as its own order.
Okay. Thank you.
I guess just the last point of that, to further complicate it, and Brent, you might have to chime back in on it, but bullet number 5, there would be instances as well where we could drill a vertical and then have to force pool that one. And then so you may have forced poolings in place out there and then come back and drill a horizontal well. Similarly, we would not want to assess a penalty. We would either modify or vacate that prior order to conform to the full unit size. And the reason we need to have those forced poolings apply to all the wells is because of the high interest of tribal and Indian allotted lands. Just about actually every single one of these units is going to require a CA, communitization agreement. And so we, to get that approved, need to have orders that apply to all these wells. And so that's just an unfortunate reality, but that's why I think it was very important to try to address it now. Again, I think we can kind of flush out the details of how that'll be handled later. But again, we're not trying to overly penalize anybody. We'll properly notify everyone and kind of go from there and see what we can do.
Move on to, this is Exhibit E. Can you please describe and explain Exhibit E?
Sure. This exhibit is all of our producing vertical wells kind of shown with our boundary on the map. You kind of touched on it a little earlier. It's kind of a funny looking boundary, and a large part of that is because we did not want to significantly impact existing production that's out here. So over the last several years, Crescent Point and our predecessor, Ute Energy, has been drilling essentially the quickest, easiest permits, the permits that we had. As you can see, they're fairly consolidated. They're kind of clustered there in the southern and middle part of our field. Not to say that we haven't drilled and participated in wells all around this area. I feel like we've defined these formations and these zones. I'll let Katie and Laura touch on that a little bit more in their testimony. But really the main purpose and the reason that it's kind of funny looking of an outline is to avoid all this vertical production that we have. So I guess another point that I want to drive home is as we continue without a defined plan and continue operating under the general well siting rules, I think this is just going to get more and more complicated as we move forward. We're wanting to access some of these harder areas. We're wanting to get permits going, and we're wanting to continue our development plan. That's going to be difficult to do without this kind of a flexible order covering a pretty good size of land. But if we continue just drilling vertical wells under the general siting rules, I think it'll be more difficult to address spacing as we go along. So that's kind of the key points that I wanted to make with this.
Moving to Exhibit F, please describe and explain Exhibit F.
Sure. We have many surface challenges in this area. The two main ones are wetlands and Scalero cactus habitat. That's an endangered cactus species. We also have topography, paleo sites, archaeological sites, residences. I mentioned before the town site of Randlet is right in the middle of these lands. I guess a bird called the yellow-billed cuckoo that all of these things have setbacks and buffers. And when you take them all into consideration, we're estimating that about 28% of the surface within this area likely will never have pipelines or a surface pad on it. It is just that difficult to access, and it is that difficult to plan our infrastructure pipelines. So again, the two main ones are wetlands and the cactus habitat. We are significantly impacted by those. And what this means is we need a clear development strategy, and they are kind of also driving the size of this, because pretty much this entire area is affected by all these issues. We need a clear development strategy that includes all these well types, vertical, long horizontals, and super long horizontals. And so we can kick off the permitting process and kind of address this as a field-wide plan. We truly think that will help us avoid waste, minimize our surface impact, and potentially reduce the amount of flaring that we have to do going down the road. If we can plan for our pipeline routes and work around some of these significant surface constraints, this is the type of plan that we need to do, and we think that this is going to be necessary for us to continue the capital deployment that we have over the past few years out here. We've essentially plucked all the low-hanging fruit. We need something flexible like we're proposing today to continue at the pace that we have.
Moving on to Exhibit G, please describe and explain.
Mr. Chairman, if I could just interrupt just for one point of clarification so I can keep up. Are you going off a different list than was submitted as part of the request for agency action of exhibits?
A different list of what, the acreage list?
No, the exhibits. I believe I'm just not sure the exhibit list that I have tracks the exhibits that were submitted with the request for agency action, and maybe I misunderstood. But for example, I don't think Exhibit F was included in the original submittal, or if it was, I apologize. I just want to clarify that. You submitted, I thought, some additional exhibits that then were not actually filed.
F was, I'm holding the file stamped copy. And
Okay,
F
okay, then
was
I
in there.
apologize. Move forward.
I mean,
Oh, that, please, it needs to be consistent.
I could see some confusion. We've been kind of scheduling meetings with the division and going out and going through some of these ideas with them for many months now. It has been an iterative process so far. I expect it could continue to be that way, working with the board and the division. We did have some initial exhibits, and then through meeting with the division, we added onto those, but I believe they all did get filed.
And they were filed with the request, or within 30 days of the request.
Correct. They were filed by
All right,
the exhibit
thank you.
deadline.
I guess
yes.
I have an earlier version. Thank you. I'll get rid of that. Thank you, Mr. Chairman. Apologize for
Yeah, you've
interruption.
screwed this up beyond all recognition. And
I'm
okay,
usually-
back to you, please.
Thank you. Moving on, this is Exhibit G. Can you please describe and explain Exhibit G?
Sure. This is, again, our proposed cause outline, and these are our designated 640-acre units. There are 45 of those in this outline. And again, to kind of drive home the point, these will not become effective until we drill a long horizontal well in those sections. So we can go about our business as we have been, drilling vertical wells. They're going to be on 40 acres, and then we can come back at some point in the future, drill a long horizontal well, and thus, upon first production going forward, establish a 640-acre unit. And so I see the benefit of this process, and the exhibits and the notifications is, as a mineral owner or as our working interest owner partners, they can look at this and say, okay, I'm going to have some vertical wells on me, and I'm also going to have some horizontal wells on me. And I know that the maximum of the verticals is 16 and the maximum of the horizontals is 12. Whereas if we continue drilling without a plan and without kind of going through this process, we just continue doing the one-offs that Brent discussed, and I think it's less transparent than doing it this way would be. So that's kind of my spiel on this slide.
We'll move on to Exhibit H. please describe and explain the information on Exhibit H.
Sure. So this is our designated 1,280 acre units. They're shown in red on this slide. So again, to just kind of reiterate the point that I was trying to just make, now all these owners within these designated units can say, okay, I'm going to have some verticals, I'll probably have some long lateral horizontals, and I can also one day have super long lateral horizontals. I get that it's kind of confusing because these are overlapping with those other units, but it is our attempt at kind of putting people on notice and getting an understanding of how this could be developed. And that's where the flexibility comes into play. I guess our key message throughout all this today is that no matter what wells we drill and what order we drill them in, we feel that the mineral owners and the working interest owners are in a better position under this plan than they would be if we continued under just the general well siting rules or trying to do this in one-offs, coming back to the board month over month and continually delaying permit timelines. So that's a key thing for me to drive home, that we think that there's significant upside in this plan. It will protect correlative rights, and it will prevent waste.
This is Exhibit I. Please describe and explain the information on Exhibit I.
Sure. Again, our outline in green there, and then in blue shows you where we are required to have communitization agreements. It's, as we drill horizontal wells, it's every single unit. So that kind of goes back to the fact that this is mostly tribal minerals and Indian Alati minerals. So for them to get paid as we drill horizontal wells, a communitization agreement must be approved through the BIA and the BLM. The slight hang-up, I guess, with this is that the CA form that the BLM uses does not directly coincide with the general well siting rules. What I mean by that is with the well siting rules that we're drilling under right now, we can do one horizontal per section, and that's on a 640, and then you can do up to 16 vertical wells, and those are on 40s. They're basically overlapping units. The CA, the form as it is, has to apply to every well within that unit boundary. So it doesn't necessarily have a clear process in place that I'm aware of that could have overlapping units like that. I might be off base. It might be easier than I'm thinking it. But as far as I know, all of the approving agencies like to have spacing orders. They like to be able to say, okay, here's an order approved by the board. I can approve this CA. And we think that this plan, I guess, more aligns with the BLM form. And then there have been other operators that have similar spacing requests that seem to be working through the BLM and the BIA. Again, I think this lends to why this area is the size that it is. If we cut any of these out, they're just more lands that need a CA that we wouldn't have a spacing order on.
The next three slides are going to be an attempt to go through the possibilities that would come through a spacing designation process and try and address how a single well in a 40-acre drilling unit would then get folded into a 640-acre drilling unit, how a 640 would get folded into a 1280, and then the final slide in this set is going to be the most complex, where you have a vertical, a long lateral, and a super long lateral horizontal all in the same spacing unit. So this will be the first of those exhibits, and that's Exhibit J. If you could please describe and explain Exhibit J.
Sure. Hopefully, as I go through these one by one, it'll start to make sense. Stop me if we're not getting there. We can always kind of go into more detail with examples. Exhibit J, this is a 40-acre to a 640-acre unit change, sorry. So we come in and we drill a vertical well that's on a 40-acre unit. that will produce on a 40-acre unit until the day that we come in and we drill the second well shown here. That is a long horizontal well. Upon first production of that horizontal well, this then becomes a 640-acre unit. That would also apply to well number 1. So it would then go from that date forward from a 40-acre to a 640-acre. I think an important thing to note is that the mineral owners in well number 1, at that point in time, they own in well number 2, and they also own in any other well that we drill within the 640 acres from that day forward.
Let me give you a sequence. You have vertical well number 1, which is drilled under the well siting rule of Utah. So you have 40 acres. The owners in 40 acres are sharing in the revenue, and then the operators are sharing in the cost. Then when the horizontal well, long horizontal well is drilled, you would have that whole area turned into a 640 spacing unit. If you drilled the vertical well number 2, it would be shared on a 640 basis?
Correct.
And that would be true as well, Mr. Chairman, for up to the 12 wells that we would be requesting in there. The point being that from a correlative rights standpoint, this proposed plan creates a situation where you're going to have owners sharing in revenue to offset their dilution in a way that is, don't see this very often. You don't see that this type of proposal for correlative rights sharing. I mean, this is the person who owns in this well number 1 is going to share in all of those other wells with literally no interest in any of those wells, and under the regular siting rules, and even quite frankly the pilot order, would never hope to share in any of those. And those rules are set up so that right now you couldn't put that where the horizontal is right now, you couldn't put it closer to that vertical than 1,320 feet. And that's some of what we're getting over. So we'll move on to the next exhibit and keep walking down that particular road.
Keep layering these in. So
this is Exhibit K. If you could please describe and discuss the
Mr. Chairman?
information.
Mr. Chairman, down here. Can I ask one question? Maybe now's the time rather than saving it for the end. You're talking about in this initial well number 1 a 40-acre unit. You've been saying 40-acre unit. I didn't see in the petition a request for the creation of 40-acre drilling units, just a reference to 16 wells per 640-acre drilling unit. But what you're talking about is requesting that the board create, until it's vacated by a later horizontal well, you're asking for literal 40-acre drilling unit spacing.
Well,
is that correct?
No, because the rules provide for that already without a board order.
Well, they provide for siting on the basis of 40 acres.
Right.
But they don't create a drilling unit that permits pooling. So if the tract is bigger if the tract is bigger than 40 acres, the sharing may not be on the 40-acre basis unless there's an actual drilling unit. So that's my question, is that the requested order, would it provide for 40-acre drilling units, or just permit siting on a 40-acre density as the default rules do?
It would be for units. Any verticals that are drilled would be on, each one is on its own 40-acre unit, and then
we'd have to add that as a concept to the overall
certainly,
program.
and that's certainly, and I understand, and again, that was based in the fact that you don't necessarily have to come and get an order for those type of units. You drill them, you designate it in your APD as a 40-acre unit for Green River Wasatch, and you would be able to then pool inside of that unit if you had to. That's the general idea when we say that until a horizontal well is drilled, nothing would change. It's exactly that. There's no orders across any of these lands, and all of those verticals would be drilled, sited on a 40-acre basis, and drilled in 40-acre units, correct?
Okay. Well, I guess I'm still maybe by the end, we just need to clarify whether there would be, the board via the spacing order would actually be creating 40-acre drilling units, because you could voluntarily pool on a 40-acre basis just under the siting rule, but if you need to force pool somebody in that 40,
And the assumption,
it can't happen under the siting rule. There
Certainly.
has to be a drilling unit created by the
there has
board.
to be, the board has to create that drilling
Certainly.
unit. Okay.
And quite frankly, I don't care too much either way. I mean, if it's more simple to leave it just under the siting rules, that's been working fine for us. And then if we do have to force pool, we could address those one at a time. Since I've been at Crescent Point, we have not yet had to force pool anyone. Hopefully that continues to be the case, but I understand the clarification that probably needs to be made in the final order on that.
Absolutely, and I would point out that the reason for that probably too is the ownership across the board is such that pooling is almost never necessary because of the ownership. It's only when there's an unleased mineral owner, and out of 28,000 acres, there's 220 of them that are unleased. So it's a very, very small percentage, and we could absolutely address that specifically in the ultimate order that's issued.
Back to Exhibit K. This is just, are we on?
They're now on Exhibit K.
Thank you, Brent. Exhibit K, this is very, very similar to the last one, where we talked about 40 to 640. This is 40 to 1280. So again, you have vertical well number 1. That's going to be on a 40-acre either siting or unit. And then you come back and you drill well number 2, a super long horizontal well. From the first production of that super long horizontal, going forward, a 1,280-acre unit is established. At that point in time, the mineral owners in well number 1 are then within that 1,280-acre unit, owning their proportionate share, and that's to any wells going forward from that point on as well.
And the effective date of the 1,280-acre unit change would be the date of first production from the super long lateral well?
Yes.
Question.
So that would be, sorry, go ahead.
So let's say in the future, there's a well number 2, a vertical well number 2, in the bottom right-hand corner of this 1,280-acre drilling unit. Does well number 1 share in that?
Yes, it would.
Does the well number 2 get any of the revenues from well number 1?
At that point, yes.
How does that happen since well number 1 already got paid out?
So well number 1 would be on the 40 acres until the unit becomes effective. So yes, the mineral owners in well number 1 would get the initial or flush production from that. As soon as the unit does become effective, though, the mineral owners down in the southeast or southwest corner that you described, they would be getting it at that point. Once the unit becomes effective, and then they would all share in every well going forward at that point in time.
Are you going to get money back from well number 1?
We're not pursuing that. If you recall, we had a spacing request. It was maybe a year and a half ago, 2 years ago, that retroactive distribution of proceeds was a very large sticking point. Steve might be able to chime in on that, but I believe it was kind of in conflict to the rule of capture. And we did not want to pursue that in this particular order. We are just drilling the wells under the rules. They're going to pay out, and then we're just forming units, and then everyone comes into the wells at those point in time. And then they have significantly more wells under this plan than they typically would.
So well number 1 gets his share of that 40-acre unit, and that doesn't get diluted after the super long lateral is built and, let's say, that well in the southeast corner is built.
He does get diluted once this unit becomes effective. So we drill
But not his initial production.
but not his initial production. No, we don't go back to that.
So you'd rather be in well number 1.
He is a lucky person, or he or she.
This is Exhibit L. If you could please describe and explain the information in Exhibit L.
Sure. This is kind of building along the concepts that we've been speaking to. In this example, there is no vertical well. The first well drilled is a long lateral horizontal, so that would establish a 640-acre unit. So everyone within that 640-acre unit shares in that well, and then any other well drilled within that 640 acres would be shared across the 640 until we come in and we drill the super long lateral. At that point going forward, a 1,280-acre unit is established, and all the wells are shared over the full unit from that date forward. So similar issues that were addressed with the vertical wells. Same concept here, you just are starting with a larger unit because you drill a horizontal well first.
Move on to Exhibit M, which is the most complex, the 40 to 640 to 1280 change.
This is just kind of combining all of these concepts in a hypothetical scenario that would involve all of these well types. So you start with the vertical, that's on a 40. You come back, you drill a long lateral horizontal. It then goes to a 640. And then you come back yet again and drill a super long lateral horizontal. At that point in time, it goes to a 1280. So you are continually building on these units, and all the mineral owners are continually beginning to share in a larger, I guess, pool, if you will. And I think this is also a really good time in our conversations with the division. There are a lot of questions how this is going to be permitted. How is the division staff going to keep track of all of this? So I would attempt to lay that out for you now. Basically, in this example, you have 3 well types in front of you, and they're all on different unit sizes. So we would permit the vertical on a 40, we would permit the long lateral horizontal on a 640, and we would permit the super long lateral horizontal on a 1280. Those would enter the division system, and then they would route through under those unit sizes. Let's say the opposite of kind of the initial scenario I described. Let's say the long lateral or super long lateral horizontal gets permitted first, and we go out and we drill that super or long lateral horizontal, or is it super long? The 1280. Super long lateral. Sorry, I'm mixing the terms here. We go out and we drill the super long lateral horizontal first, and we establish a 1,280-acre unit. We would then notify all the interested parties within this unit that we had established that unit and that it was effective on the date of first production. And then we would also notify the division of that unit being created. We would then submit an affidavit to the division that provided it would be an affidavit of notice, and we would also submit sundries on all the permits within this unit area. And so that vertical well permit would go from a 40, and it would be sundried to a 1280. And that long horizontal well would go from a 640 to a 1280 through the notification and the sundry process. And then any well permitted within this 1,280-acre unit going forward would then be permitted as a 1,280-acre unit.
This is the final land slide.
You're almost done with me, guys.
Then questions.
Yeah, and then, yeah, all right. Exhibit N, this is kind of another attempt to round it out and show you guys the development in this area. As you can see, looking at this map, we have significant vertical wells, and I've tried to identify the wells that are within this boundary line. So you have green stars that show the vertical wells that are on production that are within our cause boundary. And then you have red stars that show horizontal wells that are on production currently within our cause boundary. So you might be wondering, where did the boundary line go? I wanted to show this in kind of a different perspective because even without the boundary line on here, you can look at the development that's taken place out here and almost identify the lands without even having a boundary. All the aforementioned reasons, the surface constraints, permitting timelines, the mineral makeup, all of these reasons have really slowed our ability to develop in these areas. And it has been mostly untouched. And so that's why we're here. That's why we want the outline that we want. And to kind of bring it back to the producing wells, there's 11 verticals, green stars on this map, and then there's 4 horizontals, the red stars on this map, and those are the only wells that are would be immediately impacted by this request.
This is the final landslide, and I don't have any further questions for Mr. Waller, but I would ask the board and/or the division if there's questions at this time. It's probably a good time for it.
I think what we're going to do, Mr. Alder, I'm anticipating you're going to have more than 5 minutes of questions.
Yes.
Then I think what we're going to do is we're going to take a lunch break till 1 p.m. And then we would invite the Idaho visitors to meet with us in room 1060, which is, I think, next door, where we have lunch provided for you. And then what we'll do is we'll go into another room, the board room, and have a briefing and a discussion with you at that time. Okay, we're off the record. We are now in a break. We'll come back and we will start with Mr. Alder.
There absolutely are. There absolutely are inconsistencies. Well, he spoke, the land was one of the is in, yes?
Hey, council, let me know when you're ready.
I'm sorry, Mr. Chairman, we're ready.
Okay? Commissioner, ready? All right, we are back on the record in the Crescent Point matter. At this point, we're turning to you, Mr. Alder.
Mr. Chairman, with your permission, there were a few questions I was going to ask that I've discussed briefly with Crescent Point, just some inconsistencies that were identified between the request and some of the exhibits, and I think it would be more efficient, and they've agreed to address those on their direct testimony first. So.
Okay, then we're back to you, Mr. Chicken.
Thank you. One moment. I'm going to move forward to one of the last exhibits, none of which I've sought admission yet, and I'll do so at the end of all the questions for Mr. Waller.
Yeah, we usually prefer that we...
Correct. That's exactly what I'm doing. Yeah. So I'd like to go to Exhibit N, and I'd like to ask Mr. Waller if, please identify the discrepancy between the producing, or what I would call, I think in the RAA is referred to as existing wells, both vertical, long lateral, or super long lateral horizontals that are identified in the RAA versus what is identified on this Exhibit N.
Sure. So we identified certain wells that were on production in the request for agency action. Looking at Exhibit N, there are some stars on this exhibit that indicate producing wells that were not listed in the request for agency action. So to identify those specifically, it's the 3 stars in Section 33 of 3 South 1 East. Those are vertical producers. They're the Coleman Tribal 1-33-3-1E, the Coleman Tribal 8-33-3-1E, and the Coleman Tribal 9-33-3-1E.
Let me interrupt you just a minute.
Sure.
Just so that if someone was reading the transcript, they would be clear. There are two places where there are 3 wells. One has a vertical well between them, and the other area does not. I believe you're talking about the 3 down there.
It's the
33.
33 that are the 3 that are stacked right on top of the other, kind of towards the
toward the
southern end
middle
of
of the exhibit.
Towards the middle of the
Okay,
exhibit.
is
That's
everybody
right.
there?
Correct, in Section 33, Township 3 South, Range 1 East.
So those 3 were not listed in the RAA as being on production. And then moving over to Section 26 of 3 South 2 East, this is more towards the eastern part of this area, or the, I guess, right-hand part of the exhibit. There's also 3 stars in that section, 2 towards the bottom of the section, and then 1 in the top corner of the section. So the bottom 2 of those were also not included in the request for agency action. Those are the Gardner 14-26-3-2E and the Gardner 16-26-3-2E. Basically, the response for that is we were preparing the RAA while we were out here actively drilling wells. And so we only had so many on production at the time. We listed those. We did continue this once already. So we continued on with our program. We continued drilling wells. So that's 5 additional ones on this exhibit that were not included in the request.
Thank you. Anything else?
Yes. Also wanted to note that, just to clarify, and I'll go back to this kind of combination Exhibit M. Mr. Waller, as far as the effective date for a 40-acre, 640-acre, or 1,280-acre DU, what would that effective date be?
It would be the date of first production of that associated well. So for a 640, for instance, it would be a long horizontal, and for a 1280, it would be a super long horizontal. Again, that's the date of first production of those wells.
And just to clarify, as far as the ability to designate spacing units, and to further address some of the questions from board members earlier, Crescent Point is it correct to say that Crescent Point is looking for the ability to designate through the APD permitting process that you described earlier, 40-acre, 640-acre, and 1,280-acre drilling units?
Yes, that's correct. I think that's a distinction that was kind of questioned by the board a little bit, and then again by the division, whether these are going to actually be 40-acre units. That would be the case.
And then my final question before turning it over to Mr. Alder is, in terms of the overall scheme, recognizing that there's certain a bit of complexity here, do you feel that the ability to designate these drilling units and then sundry previously established units in basically so that we can get to the biggest unit size for a given piece of land, do you think that process from being handled on the administrative side of things is likely to be more efficient and economical than filing requests for agency action for each one of those changes?
Yes, I do think that would be significantly more efficient if we could find a way to appropriately handle that in the order that the division was comfortable with and the board was comfortable with.
I have no further questions for Mr. Waller. I turn it over to Mr. Alder.
So, Mr. Chairman, there are first a couple of questions from the staff. We'll start with Mr. Doucette, if you will allow, and then Mr. Rogers, and then I have some questions I'd like to ask.
Please proceed.
Hey, Mr. Waller, I don't want to complicate this too much, but I kind of want to go back to the 40-acre drilling unit. My original understanding of reading the request was that it would just be drilled basically according to the general siting rule on a lease basis. Now I'm understanding that is it true you're asking for a drilling unit to be established point forward once a well is drilled in this area on 40 acres, a vertical well?
Yes, that is what we're asking for. Based on the questions and the feedback, we think that that's probably the best to try to establish that now. And that would allow us to do pooling proceedings on vertical wells without having to go back and space those. We would obviously come to the board for those force pooling proceedings. But yes, we are asking for 40-acre units to be established, date of first production from a vertical well.
But if you just drilled them on a general siting and were done on a lease basis, there wouldn't necessarily be a need for force pooling in those situations, would there?
In some instances, there might be an owner that we can't locate. If it was just on a lease basis under the general well siting rules, we're not always 100% in our vertical wells. And so we may have owners that we can't locate or do not wish to participate in those wells.
And just as far as the 40-acre drilling units, are those mostly one lease? Are there split leases in those 40-acre that you're aware of? And if so, how many would that be affected?
It's a pretty good mixture. When you're dealing with tribal minerals, that is typically just one lease. But when you're dealing with fee or private minerals, it can range from just one owner, one lease to 30 or 40 within any given 40 acre.
Okay. And then as far as I don't know what exhibit it was. Let me see if I can. Exhibit D. Would that 100%, you talked about only 100% on existing wells. That was wells that have been drilled to date, but from the date of this effective order, whether they're vertical or horizontal, that wouldn't be in effect going forward.
Could you repeat that?
You had stated, I think, and I think it shows, I think maybe
Clear-
in
so
part
we're clear
4.
on the board. We're on Exhibit D.
Yeah.
And I believe it's subsection 4.
4, right.
Okay, does that get you where we are?
That's correct. Subject to my prior clarification that it should say we'll only seek 100% cost recovery rather than penalty.
And that's on existing wells, and now if I understand correctly, that would not include vertical wells being drilled point forward from the effective date, because that would establish 40-acre drilling units. Is that correct?
That's correct.
Okay, those are my questions. Thanks.
Could we turn to Exhibit M?
I'm sorry, at M?
M.
There we go.
I just want a point of clarification here. As these units evolve from a 40-acre siting or spacing, however you want to call that, to a 640 to a 1280, it spells out here what would happen as far as sharing upon that. But, you know, in the past, we've seen sometimes that horizontal wells always don't produce what they have been planned, or it may be marginal. And I'm concerned that now these wells would be now locked into a 1280 spacing, and someone would now look at a vertical and say, well, do I really want to drill a vertical when I have to share the whole 1280? Is there a way to revert back if the horizontals don't play out to a regular 40-acre spacing?
Sure. We haven't contemplated a way to revert back in the request and through our exhibits that are being presented here today. You are correct that at that point in time it would be on a 1280. And I guess what we're focused on is if for whatever reason that super long lateral horizontal was not as good as we intended it to be, at that point in time we still would have invested a lot of capital into that area because those are very costly wells. Katie can touch on that a little bit more later. And it doesn't necessarily mean that we would just walk away from this unit by any means. It would still be available to us to drill vertically or with the long lateral horizontals as well. We could still do a combination. And at that point in time, we think that any mineral owner within here is quite a bit better off than they are, at least under the general siting rules that we're drilling right now. Due to the fact that they're in a significantly larger number of wells. You can almost look at it as spreading your risk over a very large area. And so we're thinking it's a really good benefit from an upside perspective for them. I guess the short answer to your question, though, is if that longer lateral well wasn't as good as we had hoped, we would likely come back and continue development in this unit, and everyone would still share on all the wells. So they, in our opinion, would not be any worse off than they would be right now.
That's under the assumption you would continue to drill vertically. The horizontals were not as productive as planned.
That's going to be kind of more technically driven of a response. I think Laura can really hit on the geology part of that, and Katie can kind of go into the engineering as well. But I mean, yes, the way that this field is, it is going to be a combination approach where because you have a less than successful horizontal does not necessarily lend to the fact that you're not going to have successful verticals.
Well, you've presented kind of a best case, and we wish you the best here, but obviously there are some risks involved, so I just want to address those.
And just to clarify, Mr. Rogers, you know, and this may help with maybe a discrepancy that Mr. Alder might be pointing out between the RAA and the exhibits. When the RAA was drafted, we tried to contemplate exactly this issue by, instead of making those bigger units effective on first production, it was first production in commercial quantities, so that you knew it was a good well and not just a creeping along horizontal well that wasn't going to work so well. After discussions with the division, there was problems with using that terminology. And so we kind of abandoned that concept, but I don't think we're ignorant of the fact that, yes, we don't want to create a 1280 that's got 3 other verticals that we're doing just great, and then they're all pooled into this big 1280 that has a super long lateral horizontal that's just not doing what we anticipated that one to do. So building in some type of fallback mechanism, I think, is something we're completely open to, and we did contemplate that concept. It's just going backwards is obviously, it's, as we just discussed with retroactive accounting and things like that, as Ms. Davis pointed out, the going backwards is often more difficult than not. So, but we can definitely work on addressing that issue in the order in a way that the division and the board are comfortable with, that protects correlative rights in the case that we have a horizontal well that just doesn't produce at the level we would expect the horizontal to produce at.
And if I may, real quick, again, Laura and Katie are going to be able to drive this home much better than I will, but this is a stacked play. And if we went out and drilled one zone within these formations, maybe that's not the right zone, but there's still significant amounts of zones that we could potentially target with that same length of a well that would be much more successful. So just doing one well out here isn't going to kind of condemn a unit to that particular well type. There's significant more opportunity depending on the geology and things like that. So, we're still looking at this as a stacked play, targeting many zones. Some of those are going to be more successful than others in areas, but they'll really hit on that with their testimony.
Well, I just want to go on record looking at those options on kind of a worst case scenario.
Absolutely. Thank you.
Walder.
Mr. Walder, I'm really not sure where to start, but let me be clear about the 40-acre spacing. Then you would not ask this board to enter an order establishing 40-acre drilling units for vertical wells at the conclusion of this hearing. That would await a subsequent production from a well. Is that what you're asking for?
So you are correct. It would not become effective 40-acre units the day that this is approved. We would have to drill that vertical, and upon first production, it would then be a 40-acre unit.
But in Utah, normally, I mean, you said one of the reasons to do this would be to facilitate force pooling of vertical wells. But in Utah, you cannot force pool without having the well first be spaced. So does that make a difference as to whether all these lands are spaced, or would you want them spaced before you filed for your APD? I mean, I just think it's really unclear what you're asking for.
Maybe I can clarify this. The idea is that, and we absolutely agree. I mean, the normal way is you come to the board, you say, create a 640, make it effective when you issue your order, and we'll go drill our well. What we're asking the board to do is when we file an APD, and that APD is filed, then and that well is to provide Mr. Hill and his department this for a vertical well on 40 acres is APD. And then we're going to go drill that well. And when that well comes on production, then the board's order becomes effective to create that as a spacing unit as identified in the APD. So that protects from us ever trying to go back and say something else was different without doing a sundry notice. It's sort of I guess it's really a pre-approval situation, but the beauty of it is that nothing changes unless you go and drill a well that's capable of production. And if you don't, then nothing is created, nothing is established, and there's been no change and no effect to correlative rights or any waste or recovery issues at all.
Yeah, it's partly a matter of putting, finding a shoe that fits your plan or your proposal. But the shoe that we have in Utah has certain parameters, and those include that the spacing be based on an expectation that one well will drill efficiently, 40 acres, for example, and that's established before the well's drilled so that it can be used to apportion costs to the of the well to other parties and to share in production from that well prior to the well being drilled. But I think we're clear on what the differences are, and what you're saying you're asking for at this point in time then is that upon application for an APD, then unit would not be established, but it would be established with that well's in production.
Correct.
Correct. And it would be presumptively established only for permitting processes, so Mr. Hill's department can do that.
And that's until and if the horizontal well is drilled, in which case the 40-acre drilling unit would be terminated, I guess, and replaced with a 640-acre drilling unit.
Correct. And we would handle that
And
through
that would be the
notices
case
and
unless you subsequently drilled a 1280, and then that drilling unit would also be vacated and replaced with a 1280.
Correct. Oh, you make it sound so simple, Steve.
Well, I think
Thank you.
it could be problematic. Let me ask you how you propose and why you think it's fair, looking at Exhibit N.
And did you say so?
N. So that section that has the two horizontal wells in the lower right-hand corner there, those wells are drilled and producing, is that correct?
Which wells are we
It
referring
says the
to again?
Lamb 13-5, 10-4 EBS black shale, and then the Lamb 13-10-4 2E. They're two side by side, and I can't read the section number.
And
Yes, sir. Those are on production. They were drilled in our horizontal pilot that was approved last year. So we had that approved. We got our permits in, and we followed up on that with drilling and results.
Production is currently being shared on a 640-acre spacing for everybody in that section.
That's correct.
Along
that
with
is
the
also-
prohibition on vertical wells. We cannot drill any more vertical wells in that 640 right now.
Right.
There are no vertical wells in it, right? Okay, but you propose to drill, I believe, of 1280, or at least you've asked the board to approve a tentative 1280 that would include the section to the north.
That is correct.
So isn't that a substantial amount of drainage that those owners in the south half will share amongst themselves, and they won't have to share with the owners of the north half? Whereas once you drill that 1280, the owners of the north half will have to share their production with the south half. And do you think that there are other methods, or have you looked at other ways? Or how does that protect correlative rights, I guess is the question.
Our initial thought and our initial attempt at spacing was to take everything retroactive to the first production of the first well in a given unit. Again, there were issues with that as far as the rule of capture, with just administratively handling it, and basically trying to take money back from those currently producing owners. That didn't fly. We haven't come up with any other creative magic solution. We think that what we're presenting here today, though it might not be perfect, I guess I'm questioning if there is a perfect solution to that exact problem. But at least I can confidently say that at the end of the day, we're requesting to have more wells drilled with a variety of types that will help us optimize our program, and at the end of the day, drill more better wells for everyone out here. Other than that, no, I haven't come up with a creative or perfect solution to deal with that exact problem.
But if you were to drill the 1280 and it were not to be as productive for some reason as the 640, then future 640s in the north half, for example, or future 640s in the south half would have to share on that 1,280-acre basis.
That's correct. Everyone would be sharing in every well in that 1,280.
Even though they'd only be drilled on 640-acre basis.
Well, once that 1280 was established, we would notify all the owners that that is an effective 1,280-acre unit, and then we would supply the division with sundries and affidavits of notice, and then those would have been, on the permit side, changed to a 1,280-acre well.
Right.
And that would be
And-
for verticals, 1 miles, or follow-up longer laterals, super long
Right, and
horizontal.
so I guess I'm getting to the same question that Mr. Rogers asked you, only as to the horizontal wells. Wouldn't that discourage people from drilling another 640 if they had to share the production? They only get half the production from the well. They have to share it with the rest of the people in the 1280.
Well, really, it's, I guess, one key thing to highlight here is that Crescent Point's 97% working interest throughout these lands. No one else is in a position to drill on these right now. And we're the ones taking the capital risk, and we're the ones promoting development out here right now.
That's true, but there are some people that are outside of your control that will be also affected.
That's true.
Can I just follow up on that? Is your networking interest in that 97% pretty well common throughout this area?
If you look at our leasehold in this entire area that we're talking about today, and you just take an average of all of it, you come to that 97%. So
Yeah, I understand that, but
Right.
let's say that you have a lease, just hypothetically.
Okay.
You have a lease with a 15% royalty, and you have an adjoining lease to the north that has a 20% royalty. Your networking interest would be higher in that south part of that, which could be a factor in making a decision that you would drill on that south part first and then move to the north part.
Right. I
So
see
the
what you're
question,
getting at.
I mean, but if your interest was because of the lease situation, basically everything in it had a 20% lease or a 18% lease common, then that takes that factor off the table, does it not?
I get the question. Yeah, so we do have a wide variety of mineral types and lease types, and so you do have a range of royalty burden on that leasehold. So at the end of the day, it is all really quite close to roughly 18.75%. We don't have a massive swing one way or another. I can't, off the top of my head, identify any hot spots out here that have a really low royalty that we would go after first. Our program is mostly driven by the geology and the engineering, and we're going to want to drill our best wells. It's not necessarily going to be driven by our royalty rates or our net revenue based on that. We have to hit target EUR wells, especially right now with oil being the price that it is. We have to deliver barrels. So we're going to be focused on that, and we're going to try to drill our best wells first.
Go back to your land summary, Exhibit D, just following up for a second. Mr. Holder, may I?
Please.
D, so you have, okay, so on the federal, you'd assume that you'd have about 12.5%, but that's less than 1%.
Right.
State and county is, it is what it is. Fee, you could assume it'd be 18%, give or take a little bit, and the tribal would be no less than 16 2/3 to 18%. Is that?
That's right. So, like, the majority of this acreage being tribal, allotted, and fee is all kind of in that, like, 18 to 20% range. So it's not a dramatic swing for our net revenue as on a given well.
Mr. Alder, back to you.
Well, I think maybe just ask sort of a more general question, Mr. Waller, and that is, it appears that you're kind of in a tight situation between, on the one hand, not knowing everything you wish you knew about what kind of well to drill in a particular section, whether it be 1280, 640, or 40, not knowing what's going to be maximum, and a desire to have an order of the board that would establish the flexibility for you to proceed with a drilling program that would adjust as you learn more. I guess my question is, why do you need that order from the board? And do you need it effective today or the next 3 months, or do you need it? Why aren't we doing this more in a step up way of another pilot, or look at the results? We still haven't seen the results from your horizontal, and then maybe expand it. Can you answer that question?
I can. That's a great question. So as far as the do we need this today kind of an answer, we're right now assessing our 2016 drill schedule. We're vying with other assets within our company to try to get capital right now. And a lot of these wells are dependent on an order like this. A great example, when you were referring to Section 10 of 42E, that's our pilot. We can't drill vertical wells there. If we could, we might be drilling vertical wells there in 2016. So as far as the timing of it, it's relatively critical. And if we don't have a somewhat comprehensive and flexible plan in place, we might not be able to spend as much money in 2016 in Utah. And as to the size of it, that again goes back to every slide that I have that has wells on it in my land exhibits. This area is pretty much untouched. That's not because we don't want to drill there. It's because we haven't been able to because of permit timing. You have waters of the U.S., you have yellow-billed cuckoo, you have endangered cactus, and then on top of all that, all of these permits are going to be going through the BLM, and they have very, very high hurdles that they have to meet as far as their regulatory guidelines, the reviews, the surveys, and the approval process that they have to go through. So we've been permitting under the general rules, and that's 1 horizontal well per section and 16 vertical wells. We cannot fit vertical wells in much of these lands, and 1 horizontal well, quite frankly, we've deemed that to be wasteful. This is a stacked play. If we can't drill within 13, 20 feet of 1 horizontal, we're leaving significant reserves in the ground. I think Katie and Laura can hit on that far better than I can. But at the end of the day, we haven't drilled here because we haven't been able to. A plan like this will allow us to do that. And some of it will affect 2016 and certainly beyond that. So we need to get a bunch of permits in. The ones that can go through, great. That'll give us flexibility. That'll give us options. We'll be able to keep drilling out here.
Have you drilled any super long horizontal wells?
We have not operated them yet. Again, that's a permit timing issue. We submitted them as quickly as we could after getting that approved. It's been about 1.5 years now, and there's still not permits in hand. It sounds like that might be Q1 2016. That again leads to why we need this as soon as possible. We get an approval, and then 2 years later, we're doing something with it.
Why haven't they been approved?
Where's
the holdup?
The BLM. They're going through tribal minerals, and like I said, they have all of the assessments and evaluations that they have to do, and it is just quite frankly a very lengthy process. What I will say is that we have participated in several of Newfield's super extended lateral wells as a non-operator, so we have data from those. In addition with the longer laterals or the 1 mile wells that we've drilled, testing multiple zones. So we have participated, we've paid cost share, and we have data over their part of the field, which is slightly different from mine. I won't get into the geology, but Laura can cover that a bit further.
Would you mind if I asked a question here? When you talk about your 2016 drill and pan and competition between assets, could that also be, all those assets in Utah? Is it state versus state kind of competition for your capital dollars? Is it country like Utah or U.S. versus Canada or U.S. offshore or?
All of the above. In Canada, so our head kind of parent office is in Calgary, and we have sizable fields up there, and permits turn around in probably a couple of months. They can make a plan and they can execute on that almost immediately. We don't have that luxury here, so we have to do a 5-year plan that we revisit year over year over year, and we present them the permit options that we do have, and they compare all the wells that they have, the EURs, the production ads, the inventory ads, and then they're going to make a decision on what we can do. And so all of the above, we have other assets in other states in the U.S., and then we also have quite an acreage position out here in Utah as well, but this is our core operated area, and this is where we're really wanting to focus most of our capital dollars in Utah.
And you mentioned the Newfield wells. If I could ask about that, Mr. Chairman, just briefly.
Say again?
I say if he mentioned the Newfield program that they're participating in, I'd like to just ask a question or two
Please.
about. Okay.
Yeah, please do.
So with regard to those, and you mentioned that the geology may have differences, and we'll get to that with the next witness, but other than that, Newfield determined, didn't they, that it would be wasteful not to drill super long laterals, that the short lateral horizontal wells did not produce the maximum and provided and actually allowed for waste of the resource.
I didn't follow that question.
Well, I guess what I'm saying, all things being equal geologically, isn't it better to drill 1280 acre super long laterals rather than short long laterals in order to avoid waste and to maximize production?
I mean, you know, that's Newfield's opinion. I would say we have a lot of respect for their technical people. We do participate in several of their wells. But I would leave that specific question more for Laura and or Katie as to the geology, what's different between them and us, why their waste would be different from our view of waste, and why we need the well types that we need.
But does it make sense to go ahead and drill a smaller well if you don't know the answer to that question?
I'm again not following the question. They'll get to
Again,
that.
I think
It's a
these
more
are
argumentative.
little,
This is
little
technical.
geology and engineering, I think. And I think they've,
Okay,
both of those witnesses have came prepared to answer exactly those questions. So if we can pose them again, that'd be great.
Okay, thank you. Withdraw.
Thank you, Steve.
I think that's all the questions I have, unless the division has other questions. I don't think so. Thank you, Mr. Chairman.
Okay, then we're going to go to the board. Board members, do you have questions? We'll start on the right and kind of just work our way down, or so on the left, whichever way you want to do it. Let's start with you, Mr. Moon.
So tell us about the existing long lateral wells that you've drilled and what your success has been and what you've learned as much as you can. I mean, is it encouraging? How long have they been on production?
So that's another one I want to leave for
Okay.
Katie and Laura, if you don't mind. I mean, I will say in this immediate area, we've drilled 6 horizontal wells, and we're happy enough with them to be here. We want to drill more. Our executive level and our press releases, if you kind of follow our company and kind of the things that our CEO kind of puts out to the world, he's excited about horizontals in Utah. And he could see that being the future of our company out here, pending results, pending further kind of development strategies. So they can really dig into that, though, if you want to revisit that with one of them.
And Mr. Moon, I'll also note that they've applied, Crescent Point's applied for confidentiality for all those wells. We've come prepared with some of those documents, but wasn't an opportunity. Some of that information is literally a week or less new, and we've brought some of it with us, but they're just not comfortable putting it on a confidential information on something. So if the board wants to view that in a confidential setting, we can absolutely provide that to the board. We just need to make sure that it's for the board's eyes.
Yeah, that's the purpose of the pilot, is to see if this is going to work, and that's what we need to understand better.
Absolutely, and like I said, we have it. It's just we don't want anybody but you guys to see it. Like a better way to put it.
Right.
Mr. Waller, you testified earlier that you will, I believe you said, drill your best wells first, something to that effect. If you know that a well is the best prospect, why do you need all of these generalities in siting?
Again, these are getting very, very technical. I will kind of do my best to answer that. It's going to be a combination. Right now, in these difficult times with low oil, we are trying to ferret out our most highly economic projects. We can only do that with the knowledge that we have now, so far. We are still trying to do some step-out wells. We're making best guesses, trying to hit those economic hurdles and get those estimated ultimate recovery type wells. and we do have some seismic over this area, and we do have some things that can help us optimize in the short term. As far as the flexibility and the size of this, it's more to get permits in place, let us continue to process our seismic, let us continue to do some of those kind of slightly more risky step-out wells and really start defining this field, and then follow up with results from there. I can say right now that most of our drilling has been, kind of next to our best wells. Let's follow up on those, what we have known right now. And then the scope of this and the flexibility is more of a long-term focus. Maybe oil will come back up and we can justify kind of playing around a little bit more with step-out wells and things like that. But we need to get the permits in so we can do that.
Kendall, do you have any questions?
Mr. Chairman?
Uh,
Down here. Sorry, Roland. Just one clarification point. You mentioned just recently here this issue of the commercial quantities, production, determination, dictating whether a drilling unit was created or not. And it sounded like through some discussions with the division, maybe you were abandoning that. Is that still part of the request, or will the drilling units just come into existence with the drilling of the well regardless of the success?
They come into existence when that well is put on production. So obviously a well that is deemed and again, I don't think we have this danger. It's really a question of how good the well is. I don't think we're going to have a dry hole, but let's say we did have a dry hole. That drilling unit would never get created. It gets created, it becomes effective the date of first production from the vertical, the short lateral, or the long lateral, horizontal. We did have a paying quantities concept in the RAA originally, but through the testimony today, I think we've and at the behest of the division, we've abandoned that concept for specific, for exactly that reason. It was just, there was a lot of things that we had to deal with, and that was something that seemed like it was easily abandoned, that we could easily abandon it and take the frustration away that was there, because that's literally the only reason I used that term in the RAA was, what if it's not a good well? But I think we all would agree that, for every time we could discuss any situation for any application where, well, what if this gets drilled first and it's a good well and these people aren't going to pay? Well, what if it is a dry hole? What if it doesn't produce? You have the night and day version of any one given any well, because we think and estimate and believe that, yes, if you drill this, if you drill another one next to it, it will look similar to it. But that's not always the case, and I think that's even more prevalent in this area, and I'm sure the geology and engineering folks can testify to exactly that. I mean, as you notice when we're looking at this, I mean, here's 3 wells, and if you drew a 640-acre box around them, there's a Black Lamb, the Douglas Creek, and the Douglas Creek, and they're all in a general area. That doesn't mean that you go drill. If you look at section 4 down there, you drill another Douglas Creek, and it's a great well. It might not be. That might have to have been a Castle Peak zone well. It may have have to go into one of those other zones to really be productive. And so the ability to go out there, drill a vertical well that's a test well and get a log of it and understand what that little area looks like. And we'll see with some of as I'm sure you can see in some of the exhibits, we go into pretty good detail on the continuity of the subsurface formations and those types.
Yeah, if I might chime in really quick, the commercial quantities part was just not an understood term by everyone. How do you define that? How can we all be on the same page with that being included in the order? Production is a hard thing. We all know what oil coming out of the ground is.
Yeah, no, I was just clarifying whether the request had
right.
been tweaked that way. So it sounds like it has.
It has, yes.
Right.
So we are going to production as that the term that we'll use to effective these units. And then I would, I guess, caution on paying too much attention to me as far as the technical kind of testimony. Again, we are going to try to drill our very best wells with the downturn in oil prices, but you're not always going to guarantee that that's the case. They'll touch on that a little bit more. We're just doing our best trying to, keep it going out here throughout the next few years. So,
Follow-up question, Mr. Moon.
Yeah, just kind of back to the general question, why this is all needed. And you mentioned, and so I want just to understand more specifics on the immediate constraints that you have based on the existing orders. And you mentioned one, that if, right now you can't drill another vertical well in section 10.
Right.
And if that were your next best prospect, I would hate to have us holding that up. Give some other, real examples of constraints that you have right now, because this is pretty complicated. I think it's going to take a while to process and figure out. And what are some immediate constraints that you have working under the existing orders?
Sure.
Besides that one.
Okay, absolutely. I can give you a few, and then I think they're probably standing back there chomping at the bit to jump in and answer that. I don't even want to look back. I can feel it.
Because that's what I'm not getting.
Right. So some of the ones that come to my head immediately is that under the current rules, unless we're in our pilots, which we have not been able to get permits yet, we can't just go out and drill a 2-mile or a super long horizontal. We have to go back to the board every time we want to do that. And every time basically that happens, we will get a permit in, and then we're going to be considering drilling that in 2 years. So that's another thing to, again, set us up for the long term. We can't just pick there's a black shale that's contiguous for 2 sections. We think this is going to be a great well. We can't just act on that. We have to get the permits in, and we have to get them in the hopper, and one day we will be able to, and that's what we're hoping to set that up for. Another thing under the general well siting rules is just one horizontal, and that's just one mile horizontal per section. So we might, through our vertical program or through our seismic interpretation, we might find several zones present in just one section. And so we might want to go and put 2, 3, up to 12 horizontals in there to properly get that and get the best wells that we think are there. And we can't do that right now. So that's another kind of example. Another one is we can't drill within 1,320 feet of a horizontal with vertical wells. You might find a nice kind of tight spot that we think needs more wells than just, like, say, one horizontal there, that we can follow up with verticals that are a little bit closer to that. And then again, that's why larger unit size protect correlative rights. You can push those well-to-well setbacks a little bit closer without infringing on other people's minerals, and would allow us to infill those hot spots, if you will, much more rapidly than we can right now. That's kind of the handful that I can think of. I'm sure that they've probably got more or even better detail.
Hey, we want to hear them all.
All right. Well, do you want
Yeah,
them to step up now, or?
No, we'll do it.
All right. We'll get back to it.
Okay. Other board members, second thoughts, second questions? Just a statement. Even if we were, and I believe we are, we're excited about your prospect. But we have a duty to try and fit what you're asking within the law, and we have to try and fit it within our experience. You're admitting that you don't have a lot of certainly not a complete set of information on making all your decisions. You have technical and governmental restraints. We do too. And so we're trying to figure out how to make this work. One of the questions I have that I'd like you to think about, maybe in your closing arguments, would be, okay, let's just assume that we do set all of the parameters basically as you asked for. But what if there was a circumstance that none of us can foresee, that just said, that the concept is kind of a legal one, is, yeah, we're going to do this, but for good cause shown, we might require you to come back to the board, or any party, the division could bring this issue back to the board so that we can refine it. It may very well be to your advantage to do that. that you would want to come back to the board, but have some sort of expedited way we could get this back before us for things that we can't anticipate now. So just put that in the hopper, and we'll discuss it later.
Certainly,
Okay.
and with the board's continuing jurisdiction, that's right up the alley. It needs to be up. So.
We would be open to that.
Yeah, absolutely.
We're back to you, Mr. Chicken. Do you have any follow-up questions with this witness?
I don't have any further questions, but what I would like to ask is, with respect to exhibits A to N, were these produced by you or under your control and supervision?
Yes, they were.
And they're true and correct to the best of your knowledge?
Yes, they are.
And I'd like to ask that exhibits A to N be admitted to the record.
Let's just hold off that till the end.
Oh, you want all of them at the end?
All
Okay,
the end.
okay, great, no problem.
The only thing I would ask you to consider is Exhibit C being, I understand that you, from prior discussions, there is going to be an amendment to the land descriptions. You've taken some sections.
correct.
And so Exhibit C is going to be amended
Correct.
in some way, and so I want you to clarify that when we get to that point.
Correct,
please.
and we may actually end up removing that, because that's just the RAA, and it is a part of the record already.
Okay.
So
Yeah.
we may I may ask you to just exclude Exhibit C from, because we didn't cover it, so.
Call your next witness.
Thank you. I'd like to call Laura Roberts. You please state your full. Oh, you get a glass of water first. Could you please state your full name and spell your last name for the record, please?
Sure. My name is Laura Roberts, Roberts. I am a senior geologist at Crescent Point Energy. Our address is 555 17th Street, Suite 1800, Denver, Colorado 80202.
Could you briefly describe your educational background and your...
Mr. Chicken, we have heard that Ms. Roberts testify before, I believe, and we would stipulate to her expertise, and I don't know.
Excellent. I'd like to offer Ms. Roberts' testimony as expert testimony for purposes of this matter.
Knowing her, we will accept her as a geology expert for the purposes of this hearing.
Mr. Chicken?
Yes, ma'am.
It is helpful to this board if you put people's resumes under Exhibit A, if you could do that in the future.
In the future, I will. Thank you.
Thank you.
This will be Exhibit O, and I would ask Ms. Roberts to please explain and describe the information on Exhibit O.
Sure. This is the Brotherson 1-11B4. It's the type well referred to in the RAA. This log shows the four formations typically drilled through in the Uintah Basin wells. The deepest is the Wasatch, which is Cretaceous in age. The next oldest is the Lower Green River Formation. I've called out two formation tops, which mark our common source of supply. That's shown by the green line, the TGR3, and then the Wasatch. And the TGR3 marks the top of the Lower Green River. The Wasatch is the base of the Lower Green River and the top of the Wasatch Formation. These are lacustrine deposits with rivers feeding into the lake during rise and fall of sea level. So we'll see varying different types of lithologies. We'll see carbonates, we'll see sandstones, we'll see shales, and you've seen a lot of that before, so we'll get into a little bit more detail. Above the Lower Green River is the Upper Green River, which is colloquially known as the Mahogany, and then above that is the Uintah.
Moving on to Exhibit P, could you please explain and describe the information on Exhibit P?
Yeah, Exhibit P shows a regional map showing the two cross-section lines, which we're going to discuss. The first one, line A to A prime, is going to tie in the Brotherson well, which is about 20 miles from the Ranlat field. And just so you know, the green blobs are existing oil fields. You can see that there are no oil fields known in our acreage area. That's because there have been no wells drilled there. That's what we're trying to work on here. In our And all of this acreage is within the continuous oil window, so we don't expect any dry holes. And also, Katie will discuss in further section 26, which is called out in blue box. It's oil in place calculations were done from that section, as well as that's where our microseismic is from.
On to Exhibit Q, can you please explain and describe?
Sure. Exhibit Q is a cross-section line A to A prime, which starts in Altamont Bluebell with that Brotherson well, and it goes across the central basin and ends in the Randlett area. Before I get into the details of the cross-section, I'll just remind the board of what the log data is showing. In track 1, which is like yellow and grayish, is the gamma rate curve, which in simple terms is a lithology curve. In track 2 is simply the depth, so the depth below the surface that the well was drilled. And in track 3 is deep resistivity, which again in simple terms is there oil there. And then the pink that you may see in large chunks or small little lines, those are the perforations or the active parts of the wellbore that are open or have been perforated or fractured. So on the left, we have the Brotherson well with mainly Wasatch production. That's very common in Altamont Bluebell. And then 6 wells from the left is where we'll start to see the CPE lands. And this is where we start getting into the need for the verticals versus I call them 640, I forget what Ryan was calling them, and 1280s, but please forgive me for not referring to those as he did. So I'll again take you through the cross section. We start at the TGR3, which is the top of the Lower Green River Formation. It's a regional marker. It looks pretty similar around the basin. And then from the TGR3 through the Douglas Creek and into the Black Shale Carbonate, so basically from green to green formation tops, we have deltaic lithology. So it's very spotty, very localized. These are typically why we need verticals. These can be very prolific. They can be very sandy, very gas-filled, but they're often really localized. Some of our 640s, short horizontals, have been focused in this area, and they are successful, but they are regionally not throughout the basin. And so what Crescent Point needs to do is help better find something that's more regional for a horizontal program. And where you're going to find that is in the carbonate section, so the Castle Peak, the lower Castle Peak Carbonate, and the Uteland Butte. Those are the carbonate sections, more continuous. They're ubiquitous across the field. They look the same on logs. They're vertically fractured, so enhancing that through a horizontal well, along with getting the production from above it with vertical wells and below it from the Wasatch, is going to be really important for the development of our field and the economics of the wells. So B2B prime, I skipped ahead.
Moving on to Exhibit R. Please describe Exhibit R.
Sure. B2B prime is very similar, but it's just going from south to north. So we're starting in North Monument Butte and moving up to Aurora, North Aurora. And the biggest thing to get out of here is we do see the section starting to change when we get into North Aurora and the Three Rivers area. We do know that the depositional environment changes over there. And the east side of our field is starting to transition into that different depositional environment. So when we're drilling over there, they really are step-out wells for us. So getting those vertical wells in and those step-out wells is inherent for us. Are we going to be able to drill horizontals? Is the lithology the same? We know that the shoreline is changing over there, but we also have in the northern section, we know that the geology from our seismic is very similar to what we have in central Randalat. So that consistency in those lower carbonate sections really adheres itself to the longer laterals that we've been discussing.
Moving on to Exhibit S, if you could please describe and explain the information in Exhibit S.
Exhibit S is a regional map showing EUR bubbles, which is estimated ultimate recovery, as well as known horizontals in the Uintah Basin. this is really, I really put this in here to kind of show the localized nature of what we see in the vertical development of Randlet. Again, notice there are no wells in our outlined area, or very little wells, and we have a lot of localized production that is really good from some of those deltaic sands. And then if you go over to where Newfield is drilling in the Central Basin, you'll see that those EUR bubbles are also very big from their horizontals, and those are the 2-mile horizontals that they've said have worked best for them. So what we're trying to do is take what Newfield has learned and bring that over to the Randlet field, where we have right now vertical production and 6 wells that we've tested, 5 formations in. So we really are stepping outside of our boundaries and trying to figure out what's the best way to produce this, and having the flexibility with all of these rivers and WOTUS and constraints that we have really helps us out to be flexible. And Crescent Point is very big on being flexible and able to come in and step in and drill wells when we need it.
On to Exhibit T, if you could please explain. I have the information there.
Yes, I'm sure a lot of you have seen this before. It's the outcrop published by the USGS for the 9 Mile Canyon.
Drilling into the bowl of potato chips.
Yes. Yes, it's drilling into a bowl of potato chips. So the Garden Gulch and the Douglas Creek are going to be similar to these lenses that you see in the middle picture. And that warrants itself to needing vertical development. Not to say that drilling a short vertical is going to make that well prolific. We still need the lateral or the carbonate section, as well as the Wasatch production in those wells. But and then at the very bottom of that middle diagram, you'll see a lateral section, which is you can think of that as like the lower carbonate. So it's one big flow unit with vertical fractures, which lends itself very well to horizontal wells. So this is a good example of why we need both, and how quickly these rocks can change, especially in the Randlet area, where we know we have some localized sand lenses and hot spots or pods or whatever you would like to call them.
Moving on to Exhibit U. Just for procedural matters, were Exhibits O through T prepared by you or under your control and direction?
Yes, they were.
Your opinion that the relief requested in this RAA is going to protect correlative rights, maximize resource recovery, and prevent waste?
Yes.
I'm not going to have any further questions at this time.
Mr. Alder?
Well, I guess I have just one question. With regard to whether you're going to drill a super long horizontal well or a shorter long horizontal well, which would be your preference and would most effectively drain the resource if you had your choice?
Well, it depends on the formation. But we would not drill a 1280 until we can prove up a 640.
Okay, and then would you drill another 640 until you had tested a 1280?
If it was successful, I think we would go to a 1280. If it was not successful, we would likely try a 640 again.
Okay, so would you agree that if you can effectively drain a formation or horizon with a super long horizontal well, that a smaller drilling unit would be less than effective and would be smaller than the maximum or most effective way to drill that area?
I'm slightly confused by that, but
yeah, that's because I made it so awkward. I'm sorry.
That's okay. I can tell you an example where a 640 would be useful.
Right, but and I agree that a 640 may be useful and a 1280 may be useful, but if an area is drained after you drill both by a 1280, then isn't it true that a 640-acre well would not be the most efficient and would be smaller than the size that it can effectively be drained by one well?
No, because this diagram shows that a 640 is very important in some of these lenses where we have really nice porosity, really good permeable rock. It's almost like conventional pay. And the problem with drilling a 1280 through there where you start getting those shales is our fracs cannot penetrate those shales. So we've wasted a lot of money and a lot of time trying to figure out how to frac through those shales, whereas drilling a 640 would just have kept it, we're in the sand, we know it, we have seismic, it shows it.
So you're referring to Exhibit T, which Mr. Gill referred to as showing potato chips. Aren't those the lacustrine, not the continuous sands that are normally developed by horizontal wells?
They are deltaic lacustrine, yes.
So they're most effectively developed through vertical wells, I think you testified.
Well, we have 2 640s in them now, and they are very successful.
Okay. And if you have 640 horizontal wells, does it affect the viability of drilling those wells if they have been previously drained by vertical?
Katie will attest to that. We have not seen interference yet.
Okay, thank you.
Mhm.
No other questions?
Board members, any questions? Okay, call you, either follow up
Just,
or call
yeah,
your next witness.
anything in addition to what Ryan mentioned as far as immediate constraints?
Yeah, our biggest problem is the lack of flexibility we have in our drilling program. We get word from Calgary to drill 12 more wells in Utah, and we have to come up with 12 of our best wells. And what defines our best wells is something that has stacked pay at this point, but we would love to be able to be flexible with the rivers, the WOTUS, maybe drilling a step out well that's going to add some nice reserves for us. Right now, we don't have that ability. So we are really constrained within the permitting program. And so opening the doors to that would give us flexibility. And plus now that we have seismic, we can see some more hot spots that we're itching to get to, and we just can't.
Follow-up questions or call your next witness.
Follow-up questions, I would like to call Katie Matthews. Ms. Matthews, if you could please state your full name, spelling the last name for the record.
Sure, I'm Katie Matthews. Last name is spelled Matthews.
And can you please state your employment and your general duties?
Sure, so I'm a development engineer at Crescent Point Energy. I look after the Utah properties, do all of our budget, our 5-year plan, our reserves, everything capital, all the A&D activities, all the hearings, obviously, trips to the field, meet with bankers, all of the above. So.
And have you testified as an expert before this board?
I have. This is my 6th hearing.
I'd like to offer Ms. Matthews' testimony as expert testimony for purposes of this hearing.
No objection.
Board members? She's so admitted as an engineering expert for the purposes of this hearing. Let me be clear, is it Katie Matthews?
Yes.
Okay, thank you.
I'd like to turn to Exhibit U. Ms. Matthews, if you could please describe the information contained in this exhibit.
For sure. So this is an EUR bubble map. EUR stands for Estimated Ultimate Recovery. Essentially, I declined all of those wells, and now we've put them in bubbles. So the larger the circle, the more that the well is predicted to yield. Why the outline's not there, I just wanted to remove that so you can see where we've drilled wells in Randelette. We have Ultra's wells to the east, some of BBC's to the east, and then Newfield's to the south. Ours are within the central part of the page. So as Laura and Ryan mentioned, we've drilled 6 one-mile laterals to date. We've spent $41 million drilling these wells, and we've drilled them in 5 zones. The red arrow indicates the Wasatch well, which is on production. The blue arrow is the Uintah Butte, which is on production. The Douglas Creek is indicated by purple arrows, so 2 of those in the south, one of which is in the pilot area. The black shale is indicated in a green arrow in the south, and the Castle Peak is indicated by a pink arrow. So you can see we've drilled in a variety of zones all throughout our field, some zones that Newfield's tried, but we are sort of the forefront of trying new things, new technologies. In addition to the zones we've tested, we've been trying various completions techniques, so things like open hole, ball drop completions, cemented liner, tonnage changes anywhere from 30 tons a stage to 60 to 70 tons a stage, different acid techniques, gel techniques, proppant size. There's so many iterations, hence why we need at least more than one horizontal per section, because just wells next door, you could be doing a different completion technique on each well to figure out what is the best option. There was a note in the memo that Steve submitted that some of the production data was missing from these exhibits, and as Brent previously mentioned, we've applied for confidentiality on a number of these wells due to the major capital outflow that we've committed. I do have those in a sort of appendix package, which I'm happy to go through with the board. So I do have that information, and I do have one of the wells included in here. Ryan mentioned it previously.
Excuse me, Katie.
Oh, sorry.
Just a clarification. Is this bubble representing aerial extent from which reserves have been drawn, or simply volume?
Simply volume.
Thank you.
Yeah. So I could scale those accordingly. And as Ryan previously mentioned, Crescent Point is happy and excited about the results that we've had on these 6 wells, hence why we're here at this hearing. Ryan mentioned that our CEO, Scott Saxberg, is a huge proponent of horizontal wells, and he truly feels that they are the future of our basin.
So I'd like to turn to Exhibit V. If you could please explain and describe the information contained in.
Sure, so this is a decline plot. This is how I come up with all of those EURs. On the y-axis, you have rate, so that's your barrels of oil per day. On the x-axis, you have time, so that's simply your date. So I'm just declining rate versus time to come up with what I think the well will produce over its life. So this well, this is a 1-mile Douglas Creek lateral, drilled in the south, the Deep Creek 15942E. I predict that it's going to yield 325,000 barrels. This well cost $5.5 million to drill, so pretty outstanding economics even at that capital amount. I use this type well for the recovery factor calculations, which are on the subsequent slides.
Moving on to Exhibit W. Please explain and describe the information on Exhibit W.
Mr. Chicken, will you talk closer to the mic, please?
Sorry. Turning to Exhibit W, if you could please explain and describe the information on Exhibit W.
For sure. So this table runs through some OOIP, or original oil in place calculations. So this, Laura and I worked together to come up with this. On the left, we have a log which she ran the petrophysical model on to come up with these parameters. She's much better suited to answer any questions if you have any. Just to run through the parameters of how we came up with the amount of oil in a section. So A stands for area, so obviously one section, 640 acres. H is your net pay, so this is what flags as oil rich and zones which we would perf, so that came out to be 130 net feet. Porosity of 7%, SW or water saturation of 50%. Your B naught, or oil formation factor, of 1.18 barrels per barrel. So when I calculated that with the equation, you come out to have 19 million barrels of oil in place in that section. Then what I did is just to come up with a vertical recovery factor. We do have one section in the field where we have all 16 vertical wells drilled. So I declined all 16 of those, summed the EURs up, and that came to the 1 million barrels. So that's the forecasted EUR line. Then you just divide that by the OOIP to come up with your vertical recovery factor of 5.9%. So that means that you're leaving 94% of the oil in the ground and you're taking out 6%. So obviously a ton of oil and ton of reserves left in the ground that we want to harness and recover. In the red box, this is an iteration assuming horizontal development. So based on our 325 MBBL type well from the previous slide, multiplying that out by 12 1-mile laterals per section and dividing it by that 19 million barrels of oil in place comes out to be a 20% recovery factor, so leaving 80% of your oil in the ground. So it's not as if we've gone from 6 to 80% or something utterly outlandish. We're still in a very acceptable recovery factor range, and somewhere that Crescent Point would like to get to, obviously getting more oil out of the ground. I assumed for a 2-mile lateral, that would just be sort of a 1-to-1 ratio going from 1 to 2, so a 650 MBBL EUR, dividing that out by 2 sections worth of oil in place, so 19 times 2. That also yields 20% just because you're multiplying everything by 2.
So, so that I understand what you're saying, whether it's a 1 mile, I'm referring to the red box on Exhibit W. With the assuming that either 1 mile, what we call a long lateral, or a super long lateral, the recovery factor doesn't change. So you're not getting incremental production from a 2 mile compared to a 1 mile.
And there could be. I know Newfield has had success. It is over that sort of doubling effect because of the setbacks you're harnessing on either end, and you're harnessing that middle component that you previously lost. We have yet to drill a 2 mile, so I didn't want to be overly bullish, hence why I assumed just a sort of doubling effect.
So how far apart?
So
each?
let me follow up on that, if I could. If you were to factor that in, then okay, then is it correct if I assumed that you would have substantial incremental production from a 2 mile super long lateral?
I need to do a quick calculation. Just one moment.
We'll be a little more accurate for you.
Yeah.
Well, you're getting basically 660 feet of additional production.
Correct. That much more lateral open to the
under
formation.
the pilot project rules, you'd be getting 1,280 feet under the standard 660 setback.
Mm-hmm. So assuming you maintain the 330 at either end, so if you already start with reduced setbacks, it's about a 10 to 20% incremental by getting that middle section.
Oh, were these in different strata or all 12 in the same?
So these would be in different ones. That would be
ones,
too
'cause you-
tight.
How far apart? 660 or?
I would probably do one per stand-up 160 and stagger them almost on a V. So perhaps you do 4 Douglas Creeks, you do 3 Castle Peaks, you do 4 Uintah Buttes, and you'd sort of stagger them as on your way down.
Okay.
We're hoping also to potentially have commingled facilities, not a single well battery at every location. So that'll help cut down a lot on cost and surface impact.
Aren't all in that 130 feet of, because you have pay of 130 feet. All 12 of those in that 130 feet, or that's different?
They would be staggered throughout. So if you look at the log on the left, the 130 feet is the sum of essentially the pink marks. So although we drill and we have sort of 2,000 to 2,500 feet of gross pay, within that it's only about 130 feet of net pay.
Okay. Lots of separate ones though.
Yeah.
Okay.
Back to you, Mr. Chicken.
Moving on to Exhibit X. Please describe the information contained in here.
Sure. So Exhibit X runs through the setbacks that we've requested in this RAA. I've just chosen an average stage that we typically complete on our horizontal laterals. So this is one stage, 50 tons, a crosslink gel pumped at 35 barrels per minute. So this is a standard stage that we pump, whether it be sort of 30-50 size proppant or 2040, this is typical. And this is a modeled output from our frac company, Halliburton. And you can see the colored grid in the middle of the page shows the associated frac height and frac length. So this is just the stimulated. This is not the actual propped length. Propped is where there's proppant left. Just because you frac out there doesn't necessarily mean that you've left sand there. So just keep in mind that the propped length would actually be shorter than this. So this shows a half length of 290 feet and a frac height of 75 feet.
And before we move on to the next slide, just to clarify, the request is seeking 330-foot north-south boundary setbacks, correct?
Correct.
560-foot east-west setbacks.
Yes.
And 330 feet laterally from the producing interval of any other well bore.
Correct.
Okay. You have, and can you also explain the stacked setbacks that you're looking for, the 100-foot setback?
So that would mean in between the different wells. So if we were to drill a Douglas Creek, the next lateral that we drilled would have to be that far from it on a Z perspective.
Right, so interwell vertically rather than laterally.
Yeah.
Okay. Moving on to Exhibit Y, if you could please explain and describe the information contained.
So this slide further justifies why we're comfortable with the setbacks that we're asking for. Due to the azimuth of the fractured geometry specified from the microseismic that Laura pointed out on the map previously, your half length is not actually perpendicular to the well. There's a stress regime in our basin. So the azimuth that came out of our microseismic study showed that the fractures actually trend 61 degrees west of north. So when I do the trigonometry associated with that, I'm well within a 560 east-west setback and a 330 north-south. So we're comfortable moving forward with those.
Moving on to your final exhibit, correct? Exhibit Z.
Mm-hmm.
Can you please describe the economic summary?
So Exhibit Z runs through horizontal economics. Verticals are obviously very well understood in our field and economically viable. We drilled 38 net verticals in 2015. So I wanted to run through the horizontal economics. We drilled 4 net horizontals in 2015. Crescent Point in Utah, we spent $180 million of capital in 2015. So I just wanted to run through why we're here and why we're doing what we're doing. So running through the assumptions at the bottom, I'll start there. I submitted these exhibits in late summer, early fall, so some of the dates are a little bit out of loop, and unfortunately the oil price is a little higher than today's, but we're hopeful we'll get back there soon. So the economic start date of August 1st, that's just when I brought everything back to in regards to PVing or present valuing it. Ryan already mentioned our typical royalty of 18.75%. I'm using fee severance taxes. A 75-day cycle time means from the day that we spud the well, it will be on production 75 days later. So there's a capital to on production lag. So that's reflected in these economics. Additionally, I escalate the price at a 2% inflation. So if oil year 1 is $45 a barrel, year 2 I have it at 45 times 1.02. So it's just a slight escalation. I also have a GOR or gas oil ratio of 800 standard cubic feet per barrel, escalating up to 3,000. And that's due to the fact that our pressures are depleting in the field, hence why we've also applied for water flood for pressure maintenance. Our NGL or natural gas liquids are 60 barrels per million, and that's straight from our marketing statements. We have a lot of liquids in our gas, so I've incorporated those. And then a 50% surface loss means that we use 50% of our gas for fuel on site. I've assumed an 82% differential. So an example of that is if we're using the top case $45 oil, you take 18% off. That's what the refiners essentially charge to process the oil. So you take $8.10 off, you're left with a realized price of $36.90. So significantly below what you're reading online for the price of oil. The $65 case, you take $11.70 off, so you're left with $53.30. So still a significant hit. And then, as I previously mentioned, I just assumed a 2-to-1 ratio for the EUR uptick, so just doubling it from a 1 mile to a 2 mile.
Explain that last one.
The differential?
No, the one below it. The using a 2-to-1 ratio. What is that? I was familiar with every one of those until you got to that one.
Sure. So it's what
So if you get, is it a price sensitivity? Is it what is that telling us?
it's just merely the EUR assumption. So on a 1 mile, when I declined the well, I had 325. So on a 2 mile lateral, I'm just doubling the EUR. So I'm not taking that extra part in the middle.
Okay.
So I'm saying 650,000 barrels for a 2 mile.
That portion from her prior testimony that she
Yeah.
had figured out, correct?
Okay, and then would you explain, I think capital we understand, EUR we understand, BTNPV, it's net, BT, net present value 10 I understand, BT is
Before tax.
before tax,
Yep.
net present value at 10%, ROR. What is ROR compared to ROI?
So rate of return versus rate of investment. So it's essentially the rate that you're getting your money back. So at Crescent Point, we like to aim between a 30 and 40% ROR, so very aggressive metrics.
Yeah, the comparison. So if in my head 40% ROI was a critical number, what ROR would be in the range of that?
I'm pretty sure it's the same. Or maybe my economics are out to lunch. I can.
I actually think they're
I think it's
you're
just
saying the
different
same thing for the
terminology.
same- you're saying different things for the same concept, which is what are you getting back? What's your percentage back from what you've put into it?
Correct.
Correct. And I think the ROR, you could replace that final R with an I, and it would be the same numbers.
Could
There's
be
not
a
mater-
Canadian thing.
Canadian.
Yeah.
I think that's just what was chosen. I don't think there's a material difference, Mr. Chairman, between ROR and ROI. It's what money you get back after what you put in.
Okay, and I'm assuming you're going to explain the different capital costs.
Yes. Yep. And then the last column is payout. So that's the amount of time that you've gotten your capital back. So the capital, I've assumed a $4 million case and a $6 million case. That's because our wells that we drill in the south are a little bit cheaper than the wells in the north due to depth. We also frack our wells differently. Some we do cemented liners, so we run casing all the way to the toe. Some we have open hole. So to date, and I pulled all the numbers, we've spent $41 million on our horizontals. The cheapest one we've drilled so far is in that $4 million range, and then some of our more science ones were, over double. Those were our first ones, and they had very steep learning curves. So our new estimates that the guys have provided me are 4 and 6 for a 1 mile, and then for a 2 mile, they don't actually double, which is why 2 milers are all the more economic. They just go up about 50%. So that's because you're still drilling only one surface hole, and you're drilling a 1 mile lateral, and then it's just a little bit more time for the drilling rig to continue. So what I wanted to show, at $45 oil, the cheaper laterals still hit anywhere from a 20 to 30% rate of return. So we're interested in those types of projects. This is obviously pending board of director approval, but for 2016, we are budgeted to spend $76 million worth of capital in Utah, drilling 17.5 net verticals and 2.9 net horizontals. So we're here to drill. And even at $36 oil, we obviously have a forward strip that Crescent Point uses, and we're more in the low 40s, mid 40s for that strip. So we're in that upper box. We're also expecting capital to continue decreasing due to the drop of WTI. So I suspect we could even push lower than the capital assumptions that I have in this chart. I do have an appendix with all of the economic runs on the further slides if you want to dig into any of those numbers further.
We have to assume that, go ahead.
The differential, explain that to me. Everyone else got it apparently, but is that the waxy crude discount or?
Exactly. Okay. So we have black wax or yellow wax. We truck every single barrel to Salt Lake City, and you've probably all seen the oil, but it solidifies to a solid at room temperature. It's basically a candle. So the refiners in Salt Lake charge that premium.
What is the premium they charge?
So these days we're getting deals anywhere from 82 to 85%. So that's more, you sort of take the inverse. That's like a 15 to 18% deduct off of it, off of WTI.
So, am I assuming right that if the price were $100 with an 82 at the wellhead,
Mm-hmm.
an 82% differential means that you would realize $82?
Mm-hmm. Correct. You'd
And
take
then you
$18
just factor
off.
that down for whatever the price is.
Yes.
So you have to use some factor. In all of this, I have to assume that Crescent Point doesn't have a lot of debt service.
We don't. We maintain.
I mean, there's no way you could get those kind of numbers and factor in a lot of interest payment.
Correct. And that's why we use an NPV 10. We could probably even move lower based on our WACC or weighted average cost of capital, move down to a BT NPV 5 or BT NPV 8. That's something our executives are pushing on us. So that's why we're using the metrics that we do.
Thank you.
Also why they're drilling to do other things than maintain leases.
All right, we're back to you, Mr. Chicken.
I don't have any further questions for Ms. Matthews, but I'm certain other folks will. So
Okay, Mr. Alder.
Mr. Doucette has a question, Mr. Chairman. Then I have one.
Yeah, if you could turn to Exhibit X. So in there, it looks like your example was based off of a frac job in the Black Shale, is that correct?
It was a model that was prepared for the Black Shales frac, yes.
So how different would the numbers be in some of your other horizons, some of your sands, et cetera?
So as Laura mentioned previously, there's a prevalence of shales in our basin, and unfortunately we've not had success fracking through those vertically. So I suspect that the frac height is likely even lower than that because we can't achieve the vertical growth. On a lateral growth, if we look and compare to our verticals, so if we look at our verticals fracking out into the XY, again, we've never achieved even getting halfway to the next vertical next door, so that's a 1320 away. So I suspect that it would be similar. In our budget for 2016, we do have microseismic. Our team is actually meeting with the microseismic team today. So we're looking forward to completing that type of work. So
based off of that work, that would kind of determine your spacing on some of those wells as far as or where your frac and your perfs and fracs would be.
exactly. As well, seeing as we have the 4 pilots and then we're only allowed 1 well per section, we haven't had the opportunity to try, drilling multiple wells side by side, fracking them, zipper fracking them back to back, seeing how the production interferes. We're just such early days and limited that we can't quite see what that data will show.
So do you feel safe with a 330-foot setback toe and heel then on some of the other horizons as well?
Yes, we do.
Okay, no further questions. Thanks.
Board members.
Mr. Chairman, I have.
Oh,
and Mr. Rogers has one before me.
On that same Exhibit X, I just want to get this clarified, Katie.
Mm-hmm.
This is fracture length, right? Would you have any idea what the proppant length is?
So that is very difficult or possibly impossible to discern. The only way that I think you could do it is you would frack with a traced proppant, some sort of, like, I forget what the chemical is, but something that you could log in the future. So you could see the depth of invasion and then calculate the associated prop length. So I think that's how you would do that.
But that's not
Yeah,
typically...
but it is shorter than these distances.
Oh, but You're using this as your maximum possible.
Yes, exactly. So it's more bullish in regards to length.
And Mr. Chairman, I have a few questions, if I might.
Please proceed.
So, sticking with this exhibit, you said that this is based on a model of a particular formation, but you have anticipated or anticipate doing microseismic to determine the actual fracture. Is that what you testified to?
Well, we have completed microseismic on a vertical. We didn't want to include that as an exhibit because it's proprietary and we spent a decent amount of capital on it. So the vertical inferred that we were fracking within a 40-acre tract. So within your 1320 by 1320. So if we sort of flip this around, we look at the modeled results. I look at the results that our guys have actually feasibly been able to pump, because any higher than this, we start screening out on these stages, and we know that we're not achieving the vertical growth. And then when you have the added component that there's actually the fact that these fracs are not 90 degrees to the lateral, they're actually on an angle, so you're saving even more of that distance. So I think we'll refine it over time, but from today's standpoint, we're comfortable with those setbacks.
But you do propose to do microseismic, or you have actually, I guess, done microseismic and will do more microseismic to determine the actual extent of your fractures.
If my budget doesn't get cut, yes.
And under the current 131-138 order that you've asked to be vacated, the pilot project for the horizontal wells, you're allowed to drill 6, I think, wells per section. So you could drill 2 wells closer and test the distance. That's not precluded by the existing orders.
We could, however, there's also interest in testing out all the different zones. So we don't want to sacrifice the wells within the pilot of just bombarding the one zone, because we're still in this sort of constraint of we're here to learn, it's $38 oil. So we're trying to spend each dollar as efficiently as we can.
Right, exactly. And since you are here to learn and it's $38 oil, what other constraints, why not ask for just an expansion of that 640-acre to allow for the adjacent vertical well, so you could do a 1280 and then determine, because it seemed like your prior exhibit, not sure which one it was, maybe Z, seemed to justify and support drilling 1280-acre wells, and that you are preferring that if it pays out. So why aren't you asking the board to just remove that limited constraint so you can test that hypothesis?
So I don't know if this is preemptively answering Mr. Moon's question.
Well, I did want you to answer Mr. Moon's question as well. So
I was going to ask
you
you
want
the
me
same
to
thing,
answer the full
could answer
constraint?
both.
Okay, I have a list of 9 reasons, so I will start working through them.
Would you start with the one I just asked you, though? Why not just expand to test out the 1280 versus 640 acre hypotheses?
So as Laura previously mentioned, the geology of Randelette, unfortunately, does not have zones that are ubiquitous across it. We just got our seismic back. Our geophysicist is performing an inversion on it as we speak. And unfortunately, we can't be nimble and, commit to the 1280 next door, submit some permits. We'll get them back in 2 years. And, we didn't like the geology there. As Ryan mentioned, we've submitted a bunch of the 1280 permits. We've submitted 9, and we have 3 more to be submitted in another EA by the end of the year. We went to that hearing in July of 2014, and we will hopefully be drilling in the latter half of 2016. It does not allow us to be nimble operators and flip switches as Calgary and as our executives need us to and want us to, and as we want to. So by simply expanding this one section to the east or including one section to the north, I fear that would be constraining us and leaving us exactly where we are today.
Other constraints then.
Okay.
Yeah, start down the list now.
Sure. So why do we need this today? First of all, we have 2 wells on the drill schedule. I make the drill schedule with Laura's help, and we have 2 wells in Section 10 to be drilled vertically. So I would like to keep those. Secondly, we require multiple 1-milers per section in order to test completion techniques, drainage studies, tracer studies, microseismic studies. We cannot assume that one 1-mile well per section is going to dictate the future development strategy. Even in between our 2 Douglas Creek wells, we changed our completion strategy drastically, and we will change it for the 3rd. So what I would like to do is have 4 wells in one section, and you can, dial your tonnage on the next one, dial your KCL on the next one. This is new, uncharted territory, and we need a canvas to understand and figure out what we need to do. Secondly, we cannot permit any more 2-milers right now. Right now, we're done. We've submitted 9. We can submit 3 more, and we're done. And we know that turnaround time is 2 years. So if our geophysicist says that he loves Section 1 and 12 of 3.1e, we can drill it in 2 years. So that's why we need to start today. Our regulatory department doesn't love it because they're spending a lot of human capital on permitting these wells, and often we keep them in a hopper and don't get to them. But in order to be nimble, efficient operators, we need to have options. I already mentioned the seismic. We need to be permitting wells and analyzing the seismic concurrently because of the long lead items. A strategy that Crescent Point sometimes uses is sundrying verticals to be 1-mile horizontals. That's a great strategy. However, you essentially reset the clock. So if you permit a fee well in the one spot and you want to permit it and make it a 1-mile lateral, and you now intersect tribal, you're resetting the clock, you're doing your NEPA, we can drill it 2 years later. So let's permit these wells as 1 and 2-mile laterals day 1. So in 2 years, we can actually drill them as laterals, not permitting them as a vertical, and then waiting another chunk of time to drill them laterally. We also have a number of issues. Ryan's touched on these a number of times. We have a confluence of rivers. We have a wetlands project, the LDWP in 3.1e. We have towns. We have sage grouse, yellow-billed cuckoo, cactus, arc, paleo. We need to get under this laterally. In all likelihood, 2 miles, and especially in the north where you see the 2 rivers intersecting. Our development strategy is also going to be dynamic. What I foresee in an undrilled section, we're going to go in and drill 2 verticals. We're going to see if we like it. We'll drill a 1-mile. Oh, we needed to take core. We'll drill another vertical. Let's try a 2-miler. Let's try a 1-miler. It's going to be this dynamic, ever-evolving strategy, and that's why we need to have these consistent units across our acreage. Ryan mentioned it. At Crescent Point, we build a 5-year plan. So I work with all the groups. I'm a development engineer, so I deal with accounting, land, the field, geology, or I guess they all have to deal with me. And in order for me to build a 5-year plan of where we can drill exact locations 5 years out, I can't provide that currently. And one of my last reasons is Utah and the U.S. Corp in particular is being leaned on from Calgary to be the growth engine of our company. Right now, if Calgary says, we're going to give you budget to drill 5 2-mile wells next year, we can't deliver that. We can't do that because we're constrained to drill them where we get the permits, and those are in those 2-mile pilots. And probably geology won't like them, and then we have to reset the clock, and maybe we'll drill them in 2018. So those are a couple of my reasons. In order to be a nimble and efficient operator, we need to start being able to control our destiny on this acreage and permit 1, 2, and 1-mile, 2-mile, and vertical wells concurrently.
Dollar, does that conclude your? Okay, to the board. I have a couple of questions. It's not often we get a witness before us that has the depth of decision-making that you do, so I'm going to take advantage of that a little bit. To say I think I'm speaking for the whole board in saying that we're excited about your prospect. We're just trying to, it's a case of first impression. We're trying to get our arms around it. and specifically to make sure that it somehow is shoehorned and authorized by the statutes that guide us and require us to make our decisions within that framework. I would be interested to, and I'm going to throw out a hypothetical, and so this is not a recommendation, so please just take it as a hypothetical. But what if this board was to authorize the request for agency action for 3 years, then it would terminate, but that you're asked to come back in 2 years and reauthorize it, with the idea that you're going to learn a lot, we're going to learn a lot. You've made representations as to what Calgary and your top management refers to as the growth engine. We want to rely on that, but we also need to trust but verify. And so we're just trying to figure out what is a method we could use that would give you the latitude you need to jumpstart this and go full speed ahead, but still give us a chance to fine-tune this. Or, if we find, for example, my biggest concern right now, from what I know this minute, is correlative rights. Yes, there will be some inequities, but that's embedded in the law of rule of capture. So anyway, back to my hypothetical. What would be your response to, say, a 3 and a 2? 3, it's authorized for 3 years. You're required to come in 2 years and seek reauthorization for an extended period of time.
I get their opinions or just answer on behalf of myself? Okay.
You're the expert, so I'm asking you.
So I would, So obviously we're all in agreement. I would be completely on side with that. That would give us the opportunity to have drilled some 2-milers, permit a lot more 2-milers. Also, our wells would be off confidential, so we could present production data to you without fear of our competitors seeing it in the room. So as Crescent Point, we would be open to that. We are happy to come back in 1 year and provide an update. 2 years, once a year, we'll be here. We're here to stay. We're here to grow. We just need to be able to control things and be more efficient with our operations.
And let me tell you why I threw out that hypothetical. One of our choices is to say that we have not received enough information. You've either got to refine your request based on more science, or you need to reduce the size of the proposal. And as I thought about those, I'm just trying to get a feel for how we're going to do this. I know the division, at least our attorneys for the division, has a lot of questions about how to fit this into Utah law. Not that we're against the idea, it's just how do we legally get from A to B. And so that's why I think this proposal, there might be others out there.
What about this thought? I would feel comfortable with my correlative rights being protected under this scenario. If you just had your stand-up units be 1,320 feet wide. And so if you drill on a 40, that's the spacing unit. If you drill all the way through the 640, then you have those 160 acres that are held by production. Of course, you're going to have lease line wells you'd have to share between the two stand-up 160s, or if it's a 1280, you go the full distance. If you do that, I'd be completely comfortable with this. Now, there is some complications with setbacks and things, but I think those could be worked out. But if that's done, then we're not holding a whole section or a 1280 with one vertical well, or one horizontal well, and you're basically holding what you've drilled on, and then there's not that inequity that we've talked about.
I'm going to throw that out as a hypothetical. Assuming that is a hypothetical, that the spacing went from 40 acre to 1320 for the long lateral and then also for the super long lateral, what would be your response to that?
My response to that would be under the statewide default spacing, a 1 mile already does hold a 640, the one that you can drill per section. So it would be a bit conflicting with that. Additionally, our neighbors to the west, Newfield, obviously just got approved their 1280 unit. So I think it may confuse things a bit.
But here's the difference. You're planning on doing multiple vertical wells and horizontal wells. Newfield had a couple of vertical wells, but they pretty much had concluded that area was going to be strictly 1280s. They'd even said 640s don't work. Whereas this area is right now predominantly vertical wells with some horizontal, with lots of horizontal potential. So there's going to be a lot of inequities. I mean, the reason that your request 2 years ago didn't go through is because you were asking for retroactive royalty allocation. This is the same thing. It's pushing the inequity to those that haven't been drilled yet versus equalizing the royalties in the past. I can't get past that because you're going to have huge inequities, and that's not protecting correlative rights. Whereas if there is a way, and I know it's not the way we've been thinking about horizontals because we always think 640, 1280. But if there were a way to do that, I would be perfectly comfortable with everything here. And it's fair to the royalty owner.
And Ryan, correct me if I'm wrong, but the previous spacing that we applied for was going to be a vertical holding a 640. So that's a major step change from last spacing to this, is that a 40 is still its usual, or sorry, a vertical is the same. So until we drill a horizontal, nothing has changed fundamentally in these undrilled sections.
Any other questions? Are you through? Ask more if you want to. Any other questions of the board? Yes.
I think what you're proposing, especially from a technical standpoint, is probably a pretty good approach to maximize the resource. The oil's there and it's in a big section and you need both vertical and horizontal to do that. I think what we're obviously grappling with here is other kinds of issues, correlative rights and various legal issues, and that's how we'll approach this. But I think your thinking on the way you want to approach it is pretty sound. We'll have to see what we can come up with.
Yeah.
Okay, seeing none then, we're still with you.
But I have exhibit admission.
We'll have
and a
exhibit
quick
admissions.
and a quick closing left, and I don't have any further questions. So
Okay,
you're called, Mr.
let's,
Chairman.
and then Mr. Alder, might just ask you procedurally, how long do you think you're going to need for your case?
As our usual practice, we have not prepared a witness to counter any of the testimony, and we would just have a comment, a closing comment. It would be helpful for us to have 5 minutes or so to decide exactly how to respond, given the comments that the board has just made.
Okay, well, let's take care of the procedural matters, and then we'll have a 10-minute break. Procedurally, we're now at the point of admitting exhibits.
Correct. So my last questions for Matthews are first, is it your opinion that the relief requested in the RAA will protect correlative rights, maximize resource recovery, and prevent waste?
Yes, I do.
And with respect to exhibits U to Z and the appendices there too, were those prepared by you or under your control and direction?
They were.
And I would like to request that exhibits, based on the testimony of Mr. Waller, Ms. Matthews, and Ms. Roberts, I would like to ask that exhibits A through Z and the appendices there too, excluding exhibit C, be admitted to the record.
Objection. And Mr. Chairman, if I might just clarify, there was a mailing certificate that is, and I don't know if that was filed with the board.
It was filed with the board.
Right,
It is part of the record.
Just clarify that that's part of the record as well.
Yes, the certificate of mailing in this RAA there's actually two of them because we continued. We mailed it. We mailed
Yeah.
twice. Both of those are filed with the board and are part of the record, and were used as the basis for the mailing of notice of this hearing by the division and Ms. Carter to the interested parties.
Any objections to that?
No objections, just sometimes they're included as exhibits. I just want to be clear. Thank you.
The board members, any objections? Okay, to be clear, exhibits A through Z, including the appendixes, with the exception of exhibit C, and any certificates of mailing and supplements to exhibits to this, the certificates of mailing will also be admitted if they're prior to today.
To the record, correct. Yes, sir.
Those are so admitted and entered into evidence. Okay, we are going to take a 10-minute break. Board members, let's take board members, let's take 5 minutes to just talk about procedurally how we want to go, and then so we're going to take a 15-minute break. 5 minutes to just talk about things and 10 minutes for a break. Could we just go in this room right here? Gas and minings,
Let's wait and see if they want somebody else.
Mr. Alder, back to you.
Thank you, Mr. Chairman. I think maybe Mr. Rogers will briefly sort of give a general reaction of the division, and then I have some specific comments that I think will be consistent with what he says. And so we'd ask, are you all right?
Okay. Thank you, Steve. This is a very complex issue, as we know, and the idea of putting horizontal wells with vertical wells is something I don't think in any case will ever be perfectly fit together. There'll always be someone that has been shorted or gained on the system. But we are encouraged with the effort that Crescent Point is going forth with in drilling in this area. With the horizontal, if you give them such a strict rules, that then it would be difficult. So we are supporting what they're doing. Issue with people not wanting to drill and with limiting it. Some issues we'd like to raise is, first of all, we think it needs to be clarified on the 40-acre spacing versus 40-acre siting. That's something that's been confused the whole day. We would just say, why not go ahead with the 40-acre spacing right now and forego this whole issue of 40-acre siting? Yeah, I think that confuses the factor. The issue that Mr. Moon brought up was about the, as I understand this, the striping of 1320 long.
1,320 feet wide,
Yeah.
however long you drill.
So 4 per section.
4 or 8 for 2 sections.
We have concerns with that, being that there will be setback issues, lease line wells, and issues that we are not really set to deal with on a permitting anything. We'd just be more comfortable with this 1280s as they are, similar to what was happening with Newfield. That's just our opinion there and how we feel. Proposal that you sent forth, Mr. Gill. Just to be fair, you've used the term quite often, rules of the game, and I'm not sure 3 years. As far as extending the 3 years, gives Crescent Point the ability to get in there, drill, being that a lot of these will be there's some issues to address, and I'm not sure 3 years would give them enough time to get enough wells in there drilled, and maybe that might limit their ability to set forth long-term plans. So we're always talking about rules of the game. I think they may need a lot bigger time frame than that. I don't know. That might be something for they consider also.
Just so we're clear on that, Crescent Point, one of the things that's important to this board is to let the players know what the rules of the game are before they enter the field. And that's a good point, and that's what he's referring to.
Yeah, but we are supportive of having a cutoff time and to look at this. So there's some future out there. I'm not sure the ideal time frame, but we would hate to see this put out there and all of a sudden things change and now we have this this unique spacing situation and now is hanging out there for who knows how long if this didn't come forth with what Crescent Point had planned. So we think having a cutoff date would be beneficial to come back and report. So the time length on that, I'm not sure. But we're supportive of this, and we think that this will go a long ways to, enhancing, recovering the area, and also supporting production. So, Steve, you had some issues.
So we've established, this is kind of like a reverse Cinderella story. We love the girl, but we don't have a shoe, and we're trying to find a shoe to fit the situation. At least that's how I see it. The problems are many. Some of the problems are statutory. Some of the problems have to do with the fact that this has morphed during the hearing into something different than was requested. And so, and it's a pretty fast to look at a really big concept. And the feeling I have is that it would be much better if, given the discussion and the testimony, if some form of order is submitted. I don't want to have this have to come back again and be another hearing about the same thing, but there are some issues about what was noticed as opposed to what might be granted. And whether this has to be noticed again, we really are talking about some things that I think we still need to discuss between the division and the applicant to decide what actually works. And so I didn't hear anybody say that this has to be approved today. And I would think that some of the issues that I'm going to raise in just a minute should be thought about and crafted by counsel for the board and counsel for Crescent Point and the division to make something that will not set bad precedent and will work in a way that's consistent with the limitations of the board and under the statute. One of those is this concept of a drilling unit becoming effective upon production. And that's not the way that the statute's written. The statute's written that you come with engineering data and with production data, and you put on the evidence that supports a particular type of drilling unit that is consistent with that production or that economic model of development. And so that's one of the reasons that we think it would be better for vertical wells to just establish that there will be 40, I think there has been testimony that 40 acres drains, 40 acres is pretty effective for draining vertical wells to drain these formations. But as to the conversion and establishment of drilling units based on production from horizontal wells, that's problematic from how it complies with the statute, as well as what the data is to support it, and what you do if you need to force pool one of those, and how do you permit a 1280 prior to there being a drilling unit, because you have to have a drilling unit to do a 1280. So the language and exactly how that gets worked out, maybe the board has authority under its powers to establish that a drilling unit will be established upon application for an APD based on evidence that's been presented here. But that's sort of a novel thing that I think we ought to kick around for at least a couple of weeks and see if we all agree that that works. So that's one of the items. In the memorandum, I identified some things that I don't think were answered. And as was pointed out, we have not received the production data that has been represented as being confidential. But it seems that it's foolish for the board to have that data available to it and not look at it before it makes this order. And the division would also like to have that data and look at it if it's a basis for this request. As to the specific questions that were listed, they're in the memorandum. I think the legal description, of course, has to be modified, and there's been no formal submission of the modification, and I suppose we could conform it to the testimony, but I would believe it would be better if we're going to address these other issues that we submit a request with the correct legal description, and that we include and correctly identify the wells that were included and that were not included. I think I've talked about the delayed application question. And how the division would approve APDs prior to spacing. We need to address that. And I think that would also take care of the force pooling. So that's kind of a quick summary. I know we've got a party, and I sure could use one. So I was thinking...
I'm going to take the chair's prerogative right here and suggest...
So I think that's all we have to say.
I'm going to take the chair's prerogative and suggest something.
I will be...
We're trying to figure out how to get the board together to take this under advisement. I do think that we have a legal notice issue that we've got to cure. So what I'd like to suggest to the board and its counsel and to the parties is that we will continue this to the January hearing. This hasn't been voted on. This is just a suggestion, with the idea that you will, with the direction that we're encouraging this, that we don't want it to not happen, but that we've got to figure out on this case of first impression how to fit it within Utah law and then how to solve this notice problem. I think that's a serious issue that we can't ignore, even if we liked it. So we've got a certain amount of time that we have to give notice, because we've changed enough from what was given to the public that we're not where we need to be. So I don't know how that feels, but I'm going to, that's just a comment. Now back to you, Mr., for closing arguments and comments on that proposal.
There are certainly not going to be arguments. I'm going to try and respond directly to some of the division's concerns. First concern, whatever order comes out of this, we'll establish the 40-acre spacing. Write that in there. We'll have it established. That'll be taken care of. Second, Crescent Point is fine with and appreciates the division's comments on the time. We would be fine with a 5-year sunset, but 1-year reporting periods. We'll come back in 1 year, and then every year after that, during that 5-year period, and provide this board with information of what we're doing, where we're going, and it won't be limited to the well data and information as it comes out of confidential status and things like that. As far as the order goes, I'm absolutely fine with working closely with the division, particularly its lawyers, to come up with an order, and then we can either, I don't know how we renotice the application, but I mean, we could do, we're happy to do either. We're happy to draft up an order and then send that to everybody and provide them with a 30-day period in which to comment on the order or something, whatever the board decides.
During that period, what we would ask is, not just discuss it, but work out a pro forma order.
No, correct, and that's what I'm.
Is that what we understand you're saying?
Yes, that's what I'm saying. Is like this wouldn't be final until a pro forma order is agreed to by the division. We work together to put something in front of the board.
If there is a difference on some provision, we can handle. You're giving us both sides, and then we'll decide that. But if there is a lot of common ground where there's no disagreement, let's get at least that behind us.
Certainly.
As far as
and
we can.
Could have the notice provide, I would think one option would be that if there's no objection to the reformed request, there wasn't to the original request, then it would not be necessary to hold another hearing.
Right. And we'll give them the
opportunity.
And we can work that out. I think, January 26th, 27th, I think certainly, we can, and the attorneys can provide the board, but I think we can arrive at something that would allow the statutory notice period prior to the January hearing that this is going to get approved. If you want to protest it, you can protest it, or you can come to the board and give them any information you want. That will, of course, change what happens on January 26th, but nonetheless, we're still in a better spot there. Absolutely no problem through that process. We'll defer to the division whether you want I can provide you a simple statement of the correct legal and the wells, or I can simply build that information into the pro forma order, and I'm assuming you would be looking for a draft from me first. If that's... Okay. I just want to make sure that I'm providing stuff timely as we would go forward with this. As far as the APD and the permitting process, I understand. I'm familiar with what the statute says, but I think that statute also gives the board discretion to do exactly this, to move things in a way that's not going to materially affect anybody's rights. I mean, is there really a big difference between a pre-APD and a post-APD effective date of a spacing unit? If it was a 1280 the day you submitted it, it's a 1280 the day that they're approving it, so there's no material difference, and nobody's being prejudiced in that process. Really what it comes down to is that the permitting division needs to have the authority that they can approve that without the spacing unit there, and I think the board has that discretion. Of course, you can discuss that with the board's attorney, and certainly part of that process, as we noted, is that when we did sundry and when we do give those APDs, we're going to go above and beyond what the requirements are, and we're going to provide notice to all interested parties that APD has been filed, and the material portions of that APD. So there's no... Well, and we'll work through that in the order. You know, again, the additional data, we have it with us. We just need assurances that if we were to, and we have copies for everybody. We can't give that to anybody until we have an assurance that that is going to stay confidential and is not going to be bootstrapped up into some governmental records blue sky law where it can't be left confidential.
I would support an interim order from us that says that that is proprietary, unless there's some strong objection by the division or some other party. There's statutory protections for that, and we can so order that if the order were prepared.
So and in closing, there are definitely issues surrounding this, and I think that the division's been great in working with Crescent Point. We want to continue that cooperative process. I think everybody is in agreement that the idea here is going to be beneficial overall to everyone. But in addition to that, and this is just from my personal view of this, at the end of the day, we're just asking to drill horizontals and verticals close to each other, and that's really what the impetus of this proposal is. And as somebody who's licensed in 5 Rocky Mountain states and actively practices in front of the boards and commissions in all of those states, I can tell you that this is how people are drilling wells and developing oil and gas in the western U.S. They are throwing everything they have at it. Directionals, horizontals, long and short laterals. I've done ones in Montana that are 3 and 4 miles long. That creates all kinds of correlative rights fun. But as you can imagine, this is where it's going, and I think this is an unprecedented opportunity where, except for a couple of places within the lands we're talking about that have an existing vertical well, we really have the opportunity to work with the board and the division to help Crescent Point control its own destiny on a clean slate, where we're not having to worry about old pooling orders for, and old, old spacing orders for 40s and things like that, and a whole bunch of special stuff. We've got a couple of little pockets, but basically we've got over 20,000 acres here that we can all come to agreement and figure out a way to do this that allows modern development plans to be implemented in these lands. And let's be real, there's just a lot of oil and gas out there to go grab, and I think we can work together to get that. I have nothing further.
Okay, thank you. I don't see a downside unless you guys tell us from this one part of this, and that would be to continue it to next January meeting, and then elect during that period of time whether we want to have council argue it, or just to make a decision, or to receive a report on the discussions that have gone on. But to have that on the agenda, I think, solves a lot of legal problems in terms of notice that I think makes some sense to me. Board members, could we take this under advisement, hear the next case, and then use whatever remaining time we have to discuss the procedure of how we're going to come to a decision? Let the record show that there has not been a board decision. There have been recommendations, there are some ideas, and we'll deal with that further. Thank you very much. And we send our best wishes to you during this season. We are now on agenda item number 5, docket number 2015-029, cause number S/047/0119, in the matter of reclamation at the BMC Steeps Ridge Road Pit Mine. Melissa, will you let us know when you're ready, or can we proceed immediately? Okay. Melissa, you'll have about 20 minutes. So if you need to proffer or anything like that, we can accept that.
Okay, thank
to
you. I
cause
think
show.
that April will be fine to go through it in that time.
Okay. Okay, we'll take appearances of council.
Melissa Reynolds for the Utah Division of Oil, Gas, and Mining.
Any others? Seeing none, it's to you, Melissa.
Thank you. Thank you, Mr. Chairman, members of the board. Today, for the division in this matter, I will do three things. First, I'll present an opening statement. Second, I will call one witness, Ms. April Abate. And third, I will explain the stipulated agreement and conclude the division's case. At its core, this is a forfeiture action seeking an order from the board, forfeiting a reclamation surety, and authorizing the division to use that money to reclaim a mine site. It's to reclaim the BMC Seeps Ridge Road Pit Mine, which is located in Uintah County on Sitla-owned land. Since filing the notice of agency action, the division has entered into an agreement with the surety company that's subject to the board's approval today. And in lieu of filing a response or entering an appearance today, the surety company has provided a check for the full surety amount already. Under Rule 647-3-112.1, the board may order that the division reclaim a small mining operation when an operator fails or refuses to conduct reclamation. And in this case, the operator has failed to conduct reclamation as required by its reclamation contract and by the rules. Last night, we did receive a call from Mr. Scott Cusick, who is the father of Alec Cusick, who's listed as the managing member of Blue Mountain Crushing, LLC. He called us last night at 4 p.m. Explaining that both he and his son Alec are in Texas right now, and claiming that they just found out about this hearing yesterday and that they just found out their attorney would not be able to make it to this hearing today. So when we contacted that alleged attorney, his name is Adam Rivelli. He actually works for the company that acts as Blue Mountain Crushing's registered agent. He informed us that in his capacity as the registered agent, he sent the notice to Blue Mountain Crushing when he received the notice from the division. And he also stated that his company is only the registered agent for Blue Mountain Crushing, and they have not been retained as an attorney for that company. When we relayed that information to Scott Cusick, he told us that a Mr. Tom Bachtel would call us, another attorney that might end up representing BMC. We spoke with Tom last night, and I explained the situation to him, and Tom explained that he actually has a conflict of interest in this case because he sits on the SITLA board. And again, the SITLA has an interest in this matter because it is both the surface and the mineral estate owner. So in all, Blue Mountain Crushing has not retained an attorney today. They did receive notice of the hearing. They did not file a response in this hearing, in this matter. And although Scott was wondering whether they could file a motion to continue or what they could do in order to provide another reclamation bond or to start reclaiming on their own, they haven't retained an attorney or appeared. They, even if they had filed a motion to continue, the division believes it's important to move forward with this case and that Blue Mountain Crushing has no good cause to continue this matter. Again, they received notice of the hearing and neither responded or appeared here today. In addition, as Ms. Zabate's testimony will show, Blue Mountain Crushing has had an obligation to reclaim this site since October 29th, 2014, and no reclamation work has been conducted. Briefly, I just want to point out SITLA's interest and position in this matter. Tom Mitchell of SITLA was here earlier. He had to leave and asked that I try to explain his position and opinions in this. He noted to me that SITLA appreciates what the division has been doing to get this reclamation work done at this mine site. In addition, SITLA agrees that the division deserves the relief it's asking for today, and SITLA also believes that this matter should not be prolonged any further. Today, in all, the division seeks an order, 1, approving of the stipulated agreement with the surety company and forfeiting Blue Mountain Crushing's interests in the money and in the reclamation work. 2, authorizing the division to use that money to conduct reclamation work of the site. And 3, the division seeks an order determining that Blue Mountain Crushing is liable for $22,896 in civil penalties and authorizing the division to seek those penalties in district court. Those civil penalties will be discussed a little bit later on by both Ms. Abate, and I will be more than happy to answer questions as well. During my examination of Ms. Abate, testimony and evidence will show that BMC had a permit to mine and posted a $62,200 reclamation bond. The underwriter for that bond canceled the bond, and when Blue Mountain Crushing failed to provide a replacement surety, the division issued a cessation order to the company requiring reclamation. However, Blue Mountain Crushing never reclaimed the site. Under the bond agreement, Fidelity remained liable for reclaiming any disturbance that existed at the time of the bond's cancellation, and that is a claim that Fidelity does not dispute. Given Blue Mountain Crushing's failure to reclaim, the divisions sought to forfeit the surety from Fidelity so that it could conduct reclamation on its own. And as I stated before, after serving Fidelity with the notice of agency action, its sister company, Zurich, approached the division expressing its interest in entering into an agreement whereby they would provide the full reclamation surety and the division would absolve it of the claims that we have against them. And as a result of those discussions, we've entered into that agreement that was filed on December 4th, and it's subject to the board's approval today. So again, we have one witness, Ms. April Abate, and I'd now ask that she be sworn in and call her as our first witness.
I do.
Thank you. Can you state your name and position and how you're involved in this matter?
My name is April Abate. I work for the division in the Minerals Regulatory Program, and I am the lead inspector over this small mine.
And can you explain the history of the BMC Seeps Ridge Road pit mine that it's the subject of this hearing?
Yes. BMC filed a small mine notice with us in October 24th of 2013 is when we received their application. It was subsequently tentatively approved on October 31st. Once we received the original reclamation surety from them, as well as reclamation contract and bond agreement, which is just our standard operating procedure with any approval process. And that bond was in the amount of $62,200, just as we had calculated.
And can you explain the location of this mine?
This mine is actually located right across the street from PR Springs. So if folks know where that is, it's just slightly north of the mine. And it was, the original intent of the mine was to produce sand and gravel and for road base during the construction of that last portion of Seep Ridge Road.
Thank you. And then can you explain, I believe, on what Fidelity did with the reclamation bond?
Oh, well, actually, I had a note here. I should probably explain how we came up with that bond calculation. Yeah. So the $62,200 was based on our 2013 small mine cost per acre reclamation costs that the division publishes every year. And that year, that was basically our standard costs for a 10-acre mine. We use We use at that time $40,600 for 6 acres, and then we do an initial $5,400 per acre. So that's how that calculation was derived.
You intend to make this an exhibit?
Um,
I don't see the exhibit number, and I don't see it on the
don't
exhibit
think
list.
it is, but
It's within,
Or is it embedded in another exhibit?
it's in Exhibit B. After the surety bond agreement between Blue Mountain and Fidelity, it's listed and behind that, the bond calculation spreadsheet.
Okay.
so that's how we came up with our bond calculation amount. And they did opt to do the 3-year escalation as opposed to the 5.
And then how long did Fidelity hold the bond for Blue Mountain Crushing?
So we received a notice of cancellation on July of 2014. So at that point, they had been operating since October of 2013. So then this came in the following July, and we received this letter from the company saying that they were going to cancel the bond.
For the record, is that Exhibit C?
It is. And what was the effect of this notice of cancellation?
So at that point, we required that we get, per our bond agreement, we require 90 days before an official cancellation can happen. So we need a little notice prior to officially canceling the bond agreement. And that date would take us to October 29th, 2015. And until that time, Fidelity would remain liable for any reclamation work.
And just to be clear, I think that's a typo. It's October 29th, 2014 was 90 days after
Sorry, yes.
Fidelity
Would
canceled.
have been. Okay. And then under our reclamation contracts, we do require our operators to replace the surety bond. So we did send them some correspondence in regards to that, sending them notice to replace that surety. All of our correspondence went unanswered. So at that point, when October 29th did roll around, I did issue a cessation order on this mine.
And were any penalties assessed with that cessation order?
Penalties were assessed in the amount of $396.
Okay.
And I should mention, in that cessation order, we did require that any mining activities be ceased immediately. And the SITLA lease on the property expired on November 30th of 2014. And as a result of that, we were requiring them to reclaim the site.
And this citation for noncompliance is part of which exhibit?
J.
Yes, Exhibit J.
Okay.
Okay, I would now like you and the board to refer to Rule 647-7-103.4. I will read the first part of that rule and then ask you a few questions. Under that rule, whenever a violation contained in a cessation order has not been abated, a civil penalty of not less than $750 will be assessed for each day during which such failure continues, unless the operator initiates review proceedings. So did BMC initiate review proceedings with respect to the violation?
Did not.
And did BMC abate by the deadline required by your cessation order?
No, they did not.
Has BMC ever abated their cessation order?
No.
So under the rule I just read, given Blue Mountain Crushing's failure to reclaim the site, a civil penalty of at least $750 a day will be automatically assessed against BMC?
Yes.
Now, can you explain the current conditions at the site and the division's evidence that Fidelity is still liable for all of the reclamation that must be done?
So we received notice from SITLA that the lease had canceled officially, and SITLA did requests that I conduct an inspection to verify whether or not reclamation had occurred on site. So the earliest I could get out to the property was in March of 2015, keeping in mind that the cessation order was issued back in October prior to that. And at that point, when I did my inspection, I did find that they had disturbed the full 10 acres and there was no reclamation that had been done.
And your inspection report is found in Exhibit G, correct?
Yes.
How do you know that the disturbance that existed on March 31st, 2015, when you conducted your inspection, or the disturbance that exists today existed before Fidelity canceled the bond?
So we received some aerial photos from the neighboring mine, U.S. Oil Sands, who had been doing flyover reconnaissance in that area several years prior. So we're offering these as part of our exhibits. This is the pre-disturbance area from 2011. If I can orient everybody. This is looking north, so the pit would be at the top where those trailers are off on the right-hand side of the road. So that's a general area where this pit would be located. Then we received this photo from June of 2014. This is looking southwest, and you can see here this area, area with relief is the disturbance from the BMC pit. And then just further down the road to the south is just the initial grading activities that U.S. Oil Sands was conducting just to get ready for their processing facility. This photo is pretty critical in the sense that at this stage, the permit was approved in October of 2013. They had started doing their mining. So this was the summer of 2014 when they were actively mining, and then we issued that cessation order in 2014. Okay, here's another view of the pit, just looking north now. And then a closer shot, just this past May. This would have been after my inspection. This just shows that the disturbance is still sitting there unreclaimed as of May 2015. And then I think we have a more recent, and then we have the latest photo is this September 2015.
So just to clarify, Fidelity canceled the bond in October 29th of 2014, and that was months after this June 27th, 2014 disturbance existed, and the same disturbance exists in 2015, long after the bond has been canceled.
But during the time where Fidelity was liable for reclamation.
As to the exhibits, are they part of the public record, or were they prepared by you for this hearing?
They are part of the public record.
And do they comport with your testimony given today?
We do.
I would now move for admission of the division's exhibits A through M.
Board members? The extent exhibit F that contains the photographs.
It does.
We'll take administrative notice of any of these photographs that we've been shown today because they are part of the public record. And otherwise, exhibits A through M are admitted.
Thank you. That concludes my examination of Ms. Abate, and I would invite any questions from the board that you might have for her.
Questions? Seeing none, we're back to you.
Thank you. Now, if I could briefly just address the stipulated agreement that the division filed on December 4th. As previously stated, when the division sent its notice of agency action to Fidelity, we were contacted by Zurich American Insurance Company, which is a sister company of Fidelity, now acting on behalf of Fidelity. And Zurich expressed its interest in entering into an agreement with the division whereby they would simply provide the funds to the division, and the division would resolve its claims against Fidelity. And that would happen in lieu of Fidelity or Zurich filing an appearance today or filing a response to our notice of agency action. So Zurich admits that Fidelity remains liable for all the reclamation work that needs to be done on the site. And this agreement provides that Zurich, again acting on behalf of Fidelity, would provide the entire $62,200 surety to the division. And as we've provided you all with copies of that check that we received today, so the money is in hand, it's locked away and awaiting board approval of the stipulation. It also provides that upon the board's approval of this agreement, Fidelity and Zurich will be released from liability, and the division will use the money to reclaim the mine site. Zurich understands that the division will only use the money for reclamation and will return any money that's not needed for reclamation once the division deems reclamation to be complete. That, in essence, is a summary of the stipulated agreement, and I'm happy to take any questions if you have any at this time.
Board members, any questions?
How fast can you cash the check?
I do have one question, and that's the penalties. So you've got the basic bond taken care of. You've got the up to $750 a day. What are your intentions in terms of the penalties that have been incurred? I don't know if is it 300 and some odd dollars?
Initially, it was 396 that was assessed, but since they went into failure to abate mode, that's when the $750 a day kicks in, and we could theoretically fine them up to that, well, minimum $22,896.
And if it were the sense of the board to do exactly that, could we? Is it your intention to so accomplish that?
I believe that the division's attorneys will have to speak to the division's representatives in order to make a determination as to whether and when we would actually seek those civil penalties in court. But what we're seeking today is the authority to do so and the recognition by the board that BMC is liable for the $22,896, given their failure to abate their cessation order.
So in terms of what so the board is clear, what are you asking for today? The authority to forfeit the surety.
Yeah, so
and
so
authority
today,
to move forward. There is an open question on the penalties. Is that correct?
yes, as to whether the division will actually seek them in civil court. But today, the division is moving this board to enter an order recognizing that Blue Mountain Crushing failed to complete reclamation as required by the reclamation contract and by the rules, and approving of the stipulated agreement that we've entered into with Zurich and Fidelity. Also forfeiting any interest Blue Mountain Crushing has in the reclamation bond or in the reclamation work, and authorizing the division to proceed with conducting the reclamation under Rule 647-3-112. In addition, the division is seeking an order finding that a penalty of $22,896 is warranted, and authorizing the Attorney General to recover those civil penalties in district court under Utah Code Section 40-8-9.1 sub 4.
And embedded in that is the stipulated agreement that Zurich would be, by the payment of this check, is released from
That's
further
correct.
bond requirements.
Yes, upon payment of the check and authorization or approval by the board of the agreement, they would be released from liability.
Okay. Does that conclude your presentation?
It does.
Okay, board members, there's a matter before you, a proposal before you. Do you understand the request?
Just a quick question, is that $62,200 sufficient to reclaim?
We believe it is. That it was based on our cost per acre in 2013, and those were our standard costs at the time that the division published.
I have a question.
Go ahead.
Will the 22,000 also come out of the 62 if there is any left over after reclamation?
That's essentially a separate penalty that would be levied on them if it
Correct.
goes to.
Extra, in other words, if it doesn't cost us $62,000, it's ours. Is that right?
No, it would go back to Zurich, I believe.
Oh.
Right?
Yeah, in accordance with the division's rules and the stipulated agreement, any money that is not needed for reclamation of that $62,200 will be returned to Zurich. And that, again, is in accordance with the rules.
So that money cannot be used to pay that civil penalty?
Correct. That, the $62,200 is coming from the surety company, and we're seeking the civil penalties directly from Blue Mountain Crushing.
Are you, any more questions, board members? Motion's in order. Mr. Brown.
Mr. Chairman, I would move that we approve the order as outlined by the division.
Is there a second to that?
I'll second that.
Okay, any discussion? Seeing none, the motion before you is to approve the division's request as stated by their attorney, Ms. Reynolds, and all in favor say aye.
Aye.
Any opposed? Let the record show that that was unanimous. And we would encourage you to seek that penalty. And with that, a motion to adjourn is in order.
Mr. Chairman?
Yes.
Back on the Crescent Point matter, I think we hadn't quite wrapped up what the instruction was to the parties. I'd like to have a brief discussion with you off the record.
Okay. We all just adjourn to this room for a second. We are back on agenda item number 5, docket number 2015-026, cause number 131-141, in the matter of Crescent Point Energy U.S. Corporation. The board will continue this matter until the January 2016 hearing, subject to a new notice of the petition as amended being generated with an opportunity for public response. Counsel for the petitioner and counsel for the division will work with the board counsel on the contents of that notice.
Thank you, Mr. Chairman, and counsel for Crescent Point had to catch the plane, but this is exactly as you just recited was discussed and agreed to by them, so thank you.
Okay. Thank you. And I think now we are ready for a motion to adjourn.
So moved.
All in favor, say aye.
Aye.
We are adjourned.